Welcome to the policy meeting. We have some of the commission members here in person, others are by Zoom. Am I not loud enough? We have a lot of information to cover in the next 4 hours, including some different draft language and tables and so forth on the 8th edition sentencing guidelines. So welcome everybody who's here, and I will turn conversation over to the executive director to lead us, all of us.
Thank you, Judge, and good afternoon, everyone. And first, let me be the first to congratulate you on becoming chair of the commission. So thank you, and we'll get started. Let me provide a little bit of an overview of what we hope to cover this afternoon and during tomorrow's meetings. So this is the first of 2 policy meetings. This afternoon's meeting will focus on the 8th edition sentencing guidelines, the work underway to move those forward. And then tomorrow morning, we will have our policy meeting from 9 o'clock to 11 o'clock. And there are 3 things on the agenda for tomorrow morning's meeting. The first is an overview of the work underway with rebuilding the SGS web application. As we've discussed for many years, the rebuilding of the SGS web application is sort of hand in glove with the rebuilding of the guidelines. And so we'll have a presentation on the conclusion of the application design and architectural blueprint for moving forward with the building of the rebuilding of the SGS web. So that'll be for the first half hour tomorrow morning. Presentation by JMT Technology Group, which has been our vendor, working with Christy Bundro, who's been our on-site manager for it. We'll then discuss tomorrow morning the resentencing guidelines and the parole recommitment ranges. So today is about sentencing guidelines, tomorrow morning about the rebuild of SGS web, the resentencing guidelines, and the parole recommitment ranges. And my hope is that by tomorrow's business meeting, which starts at 11 o'clock, the commission will be in a position where it can consider all 3 of these drafts for possible approval and then scheduling of public hearings in February and March of next year. So with that, this afternoon is about the 8th edition sentencing guidelines. In the materials that were provided to all members, the supplemental document, and this is all also posted online. I want to direct your attention to page 155, which is the index of the 8th edition sentencing guidelines. And you'll find that there's a lot of documents that I provided you in advance and that we'll be reviewing today. But effectively, the sentencing guidelines have a section that is the text of the guidelines. And then there are a number of tables that include the offense listings, the offense gravity score, assignments, and things like that. So I wanted to find a sort of a systematic way to go through all of this information. And so there are 2 documents that were posted this morning and that I'll be using for this afternoon's presentation. The first one, Ryan, is provided in the screen share. And this is just a crosswalk where we took the existing sentencing guidelines, the 7th edition, Amendment 6, and we identified the corresponding section of the proposed 8th edition guidelines. So if you need sort of a cheat sheet to look at what do we have in the current guidelines, where does that end up in the new guidelines, this document has that. And there's 2 sections to this document. The first one starts by listing the 7th edition guidelines and the corresponding 8th edition section. And then the last 2 pages are just the flip of that. I list the 8th edition sentencing guidelines and the corresponding section of the 7th edition. So just in case you're trying to sort of find a section of statute or a section of the guidelines in either the proposed or the previous one, this crosswalk might be helpful. But the document that we're going to focus on this afternoon is a markup of the proposed text of the new guidelines. And we did this earlier this year with the 7th edition guidelines. We took the 7th edition guidelines and we marked up the entire guidelines identifying issues that had been raised during public hearings, issues that the commission had recommended staff work on, and then we put in some of the replacement text or some of the comments that staff would work on. So we took all of that information as staff and we created new draft of the 8th edition guidelines, but then we marked it up so that we could explain the various points as we go through. And so that's what we'll do as the start of this afternoon. We'll go through the text, and then we'll turn to looking at things like specific OGS assignments, example cases under the current guidelines versus the proposed guidelines, and try to answer any questions you have or try to address any of the issues that are there. So I think that'll get us through till dinner. So with that, Ryan has posted the markup text. And so anything that's highlighted is something I'll comment on. And if you see anything that you have a question about, please raise that. I'll ask Ryan and Matt to sort of monitor those that are online to see if any members have questions or comments, and they can use the raise hand function for that. So the first thing about the new guidelines is sort of a redesign of the information. As we've been working on other guidelines like the resentencing guidelines and the parole guidelines, we came up with a format that is more typical of guidelines used or published by the Pennsylvania Bulletin. And so usually the format is the first section of the guidelines provides the authorization, the second section has a definition section, and then you get into the actual policies. So with that, we've sort of restructured these guidelines to include up front the authorization for guidelines. And there's actually 3 sections. When we talk about the guidelines, the sentencing guidelines, we talk about it as like a single thing, but we have multiple mandates that relate to the sentencing guidelines. So the first one listed is just a capturing of the mandate to adopt guidelines for sentencing. And also within that is a new provision about adopting guidelines for probation. So Ryan, if you just sort of page down through this. So the first section there, subsection A, is the authorization for adoption of guidelines for sentencing and probation. And all we've done is capture the language that's in the statute so that it's clear within the guidelines what the commission is mandated to do and what the commission is authorized to do. The second provision regarding adoption is the adoption of guidelines for restrictive conditions and the certification of compliance. So in the past, the commission was required to develop guidelines for county intermediate punishment and guidelines for state intermediate punishment. And during JRI 2, those were repealed, and the replacement was for the commission to create guidelines for the use of restrictive conditions of probation. And then there was a provision about mandating reporting to the commission and the commission creating a certification of compliance with guidelines for the use of restrictive conditions. So all of that is captured in this second section of authorization under 2. And then moving ahead. And then the third area of authorization for guidelines is the adoption of guidelines for fines, other economic sanctions, and community service. And as we've discussed before, the commission received this mandate, it seems to me back, 15, 20 years ago, and we built into earlier guidelines recommendations for the use of fines and community service, especially at level 1 and level 2 of the guidelines. We didn't give it a very prominent view in those guidelines. And so under these guidelines, we're trying to enhance that view, especially as we have levels of the guidelines that are non-confinement and non-probation levels. So this is the authority for that, or the mandate to create those kind of guidelines. And while the authorization is pretty broad in terms of any economic sanctions, at the time we received this mandate, the real focus was on the commission creating guidelines related to the use of fines and then providing a mechanism for ordering community service in lieu of fines, especially to address indigent offenders. So those are the three areas of authorization that have been added to the preliminary provisions of these sentencing guidelines. If there's no question on that, that's subsection A. We'll move to B, which is the definition section. And this is entirely new, and there's a lot of definitions thrown in here, but the idea is to try to give the user upfront a list of common terms. Some of the terms are commonly used, and some of the terms are specific to the sentencing guidelines. So this is just sort of the go-to place to find those terms. Under the current practice with the Pennsylvania Bulletin and the Pennsylvania Code, if there's a common phrase that also has some, the use of letters or some kind of abbreviation, that's supposed to be identified up front, and then the full phrase listed. So we went through and we tried to come up with definitions and common terms throughout, and to some degree tried to extract these from back in the text of the guideline. So in previous versions of the guidelines where we would have a lot of definitions sort of scattered throughout the guidelines, this moves the definitions up front so that we can just sort of focus on the use of that phrase back in the text of the guidelines. So moving on, the third area under these preliminary provisions is authorized dispositions. And again, this is sort of background information or contextual information about what the sentencing alternatives are available to the court. And we had this blended into the text of the guidelines otherwise, but again, in trying to use this format of putting the preliminary provisions up front, this is a section that just identifies what the sentencing alternatives are for the court to consider. The use of confinement, whether it's county or state, the use of probation, whether it's standard or with restrictive conditions, and the use of other sanctions that we often refer to as restorative sanctions that may include things like guilt without further penalty, economic sanctions, and so forth. So those are the authorized dispositions that are listed. And then continuing the fourth and final section of these preliminary provisions, or these preliminary provisions, are authorized programs. And this is actually a cut and paste from the current guidelines. Back in sort of the back of the guidelines during the Amendment 6, we created a whole listing of all of the county and state sentencing and correctional programs available to the court. And the reason we did that was we were encouraged as part of JRI 2 to make sure courts could recognize and that we were recommending the use of things like drug treatment programs or state motivational boot camp or reentry programs. So we spent a lot of time during the last edition of the guidelines building up this section, and we effectively cut and pasted it up to the front section. So all the definitions about all those programs is included here. We did some modest updates if there have been changes in the statute. So that concludes this entirely new section that takes, 8 or 10 pages of the text of the guidelines, but it's the new preliminary provisions of the guidelines. So that's your context for that. If there aren't any questions on that, we'll move to the next section, which actually gets into the meat of the guideline. All right. So we're now at page 10. See how fast that went? So at page 10, we start section 303.2, the guideline sentencing standards. And I'll start to reference some of the highlighted areas as we go through this. The first section, the general provisions, are just a repackaging of what's already in the guidelines. There's not much of substance that's different there. One of the one of the changes that we made was, if you look at old guidelines, we had an entire section that gave sort of the lineage of the guidelines, the first set of guidelines and all of the changes to the guidelines and the dates of the effective dates of that and so forth. And it seemed that it was better to just put that in a table that you could update instead of having it in the text of the guidelines. It would be easier to reference and it was easier to update. And so we removed that and we created the first table that I'll talk about, and that's table A. And it just has a list of all the guidelines and the effective dates of the guidelines. And so that was, it's just a practical kind of change that we made. The next section or subsection of the guidelines, sentencing standards, deal with procedures at sentencing. And we had this before, but clearly our procedures are changing because we've come up with a different way of doing the prior record score. We've talked about taking into account other factors at sentencing. So this was modified to some degree. One of the, I think the most significant change, and this is something we'll talk about later, is that we've talked about including a list of aggravating and mitigating factors for consideration by the court, where we didn't have that before. We also talked about some type of general guidance about the use of concurrent and consecutive sentencing. And in addition to that, there has been discussion about the sentence recommendations we have under the guidelines are very focused on, are very offense specific. What is the offense gravity score for that conviction offense? What is the prior record score? What's the sentence recommendation? What's the sentence imposed by the court on that count? But it's rare that there's a single count. And so all of the programs we talk about, like state drug treatment program and boot camp and other things like that, don't talk about imposing a program on a specific count. They talk about imposing a program or recommending a program on an offender, on an individual. And so we've created this sort of secondary recommendation about the judicial proceeding, about the sentencing hearing and the aggregate sentence. And this would not be a recommendation that we consider in terms of conformity to the guidelines. Because right now, when we look at each individual offense and the sentence imposed, we're able to sort of benchmark that and say, oh, that was a sentence in the standard range, or that was a departure below the guidelines. When we get to this judicial proceeding, whether a judge sentences concurrently or consecutively, the aggregate sentence, the use of these special correctional programs, that's more the commission just as a policy statement saying, here's a best practice, but you have to look at the individual circumstance and you have to decide what to do. So we're not going to be scoring this for conformity, but at least we're putting in the guidelines some starting points for sentencing. And that doesn't exist now, so that's a new section. We'll talk about it in detail as we get towards the back of the text of the guidelines. The third section is about reporting information to the commission. And this is, again, we've had this in the guidelines since the very start, but we've built into this the notation or the recognition of that certification of compliance, the importance of reporting information to the commission. And we have one other thing here, and this ties into the rebuilding of the web application. Right now, if you look at our guidelines, we have an example sentencing guideline form. It's just it's sort of a rigid form, and you either fill in the boxes or you don't, but it's the same form in every case. But as we're moving to developing this new web application, the idea of a report rather than a form makes sense, because you have very different sentences, a lot of different information, and sometimes you're filling in a lot of spots or slots, and other times you're not filling anything in. And so if you think instead of having a rigid form and just identifying all the information that's necessary for the court and presenting that in a report form, that's at least something we're looking at with the new guidelines. So, or with the new application. And so in this section where we talk about completing a guideline sentence form, we also include the phrase sentence information report, so that we have some flexibility in sort of the mechanics of how that information is provided to the court for consideration and what information is then reported to the commission. So I just wanted to highlight that because we'll have a discussion of it tomorrow morning. So that's effectively that next section. So that takes care of the reporting of information to the commission. These are sort of the preliminary things. So I think we've covered most of the preliminaries and we're going to get into the actual development of the recommendations. So just wanted to check if there are any questions at this point. So we're going to move this at the bottom of page 11 to offense gravity score. And we have always had offense gravity score as part of the sentencing guidelines. The offense gravity score is a value that's assigned based on the seriousness of the conviction offense. The difference is that we presently have a 15-point scale, 14 general OGS categories, and one category, OGS 15, for murder 1 and murder 2. And now, at least under the proposals we have a 36-point scale, 30 general OGS categories, and 6 that relate to murder 1 and murder 2. So there's an increase in the number, and that gets to this whole idea of trying to have more refined recommendations, more focused recommendations. So, so that's the first part of the change with the offense gravity score. It's just the increase in the number of categories available. The next change, as we move through, is the recognition that that for certain offenses, for a lot of offenses, we provide a very specific offense gravity score assignment based on the seriousness of the offense, the grade of the offense, and elements of the crime. But the commission has always been able to subcategorize offenses, look at an offense and say, based on the sentences received or based on other factors that are commonly associated with this offense that might not be elements of the crime, we're going to give a different OGS assignment to that. So a really easy example is just thinking about drug offenses. For PWID, for possession with intent to deliver, we have lots of different OGS assignments that take into account the type of drug, the quantity of drugs, and the grading of the offense or the statutory max. And so we have a lot of different subcategories for drugs. There's not just one value for PWID. When the commission first started in the 80s and we looked at burglary, at that time, there was just a single burglary. Burglary was a felony 1. But the commission at that time established 4 different types of burglaries based on whether it was a house or a person was present, because it reflected what judges took into account outside of the elements in coming up with a sentence. So I just point that out because one of the things we do with the guidelines is we spend a lot of time subcategorizing offenses, looking for different trends and coming up with different assignments. So when we get to talking about the offense list and you see, 50 pages of offenses, it's not because there's all of those offenses, it's because there's a lot of subcategories that we look at. We're building off that approach in 2 ways under these new guidelines. First, we've talked about all of the enhancements the commission is required to build into the guideline. And one way of dealing with the enhancements to simplify it is dealing with it almost like subcategorizing offenses. We just say, here's the OGS assignment. And when this factor is present that requires an enhancement, like deadly weapon possessed or deadly weapon used, we're just going to build in an increase in the OGS assignment by 1 point, 2 points, 3 points. So we have 20-some enhancements we're required to put in the guidelines. And we're trying to use this system of having standardized OGS assignments so that we can just increase the assignment by 1 point or 2 points or 3 points to incorporate all these enhancements into the guidelines and simplify the guidelines. Judge? Your mic.
Yes. If you're sentencing somebody and we want to figure out if they're moving up, is there going to be, or because just in terms of functionality, judges or whoever's, what are they looking? There's 20 of them. That's in what format or how is that?
Sure. It's a great question. And that's one of the reasons why we're coupling the development of the guidelines with the rebuild of the application, because this should all be automated. So the idea is within the application, you identify the conviction offense. And with the conviction offense, there may be different subcategories. So there might be different OGS assignments based on factors present, just like there are now. So the user is just going to identify the correct OGS assignment for that conviction offense. And then, effectively the next page is just a list of any enhancements that could apply. And we can use the logic of the details to just present the list of those things that are possible, right? Because some enhancements apply only to these kind of conviction offenses and not these type. Like, for instance, we have the youth in school enhancement. It only applies to A30, right? So we wouldn't present that if it was a burglary of a conviction offense, because it's not in the mix. So that's one of the things with the automation. We can effectively present a list of only those enhancements that could apply. And then it's just a matter of just checking the box if it applies. And if so, it will automatically adjust the offense gravity score and list any of the enhancements that apply. And then it will calculate the guidelines based on that offense gravity score, that adjusted offense gravity. So we do have in the materials, and we'll talk about this later, I think it's a 2-page list of enhancements that has the point value. How many extra points do you get for this? And we'll have to look at that to see if there's any changes that need to be made, but that was built off the current enhancements. If the enhancements say, increase by 6 months, well, maybe that's one step. And so that's how we automate it. And from the end user, reliance on using SGS Web should be their friend, because it will automate this process. So the other type of matter for the offense gravity score is something we talked about in the last couple of meetings, and that is, what are the appropriate OGS assignments for DUI? Because right now, DUI, under the guidelines, we have sort of a default just based on the grade of the offense. We say, here's the sort of the default OGS assignment based on the grade, and then the mandatory minimum supersedes the guidelines. And that's generally how it works, except DUI is super complicated in terms of all the factors that go into the mandatory minimums and the grade of the offense. And so what the commission staff did in this rebuilding of the OGS assignments for DUI is sort of reverse the system. We basically said, since a mandatory minimum sets a floor for sentencing, let's start by assigning the OGS based on the mandatory minimum. And then let's see if the statutory max warrants increasing the OGS. And we think that actually works much better in terms of the OGS assignments for DUI. And it's much more linked to the DUI mandatories, which supersede anyhow. So we spent a lot of time like rebuilding the DUI OGS assignments. And then we use that as a template to do the assignments for voting under the influence, which has some of the same mandatory minimum provisions. And so we use that so that we had consistency between voting under the influence and driving under the influence. So those are just other examples of a lot of tedious work to come up with OGS assignments that sort of make sense in the field and are responsive to what we heard, especially about DUI, that the recommendations weren't good fits. So I think that's something worth looking at, and we'll go into more detail later, but as we're talking at this high level about offense gravity score, those are some things to consider.
But when we flip now in our books and go through this and go to the chart, but if you for the chart, it has most offenses.
Mm-hmm.
And now it tells you like how many paragraphs. But is something like that still gonna?
It is, and right now we have table B 1 and 2 and table D 1 and 2, are about, 60 or 70 pages of individual offense listing. One of the things the commission can think about, and we talked about this before, is are there sections of statute or chapters that are just, there's nothing particular about it. Like the OGS assignments are just based on the grade of the offense, the omnibus score. And if we find big chapters that the commission has not done any special assignments, maybe we just remove those from the listing just to keep it simple. And the default is the omnibus score, because the omnibus score is what we set up as the default if you have an offense that wasn't assigned. So, we have a lot of detail there, and the commission can decide how much of that detail do you publish and make available versus you just rely on the omnibus score as sort of the fallback, the default for the assignment. The final thing I'll mention is that keep in mind that whatever we give to users within the SGS web application, we have to have it's a computer. So we have to have a value for every offense, every instance. So we're going to come up with that huge list of every possible offense with a value for it, an OGS assignment. The question is, does a regular user need to have 60 pages of offenses, or would 20 pages be more manageable if they were offenses that were particularly that the commission actually defined?
Can I jump in here?
Please.
Because yes, I mean, I've had some discussions with some of my colleagues and they're like, oh my goodness, it's going to be that many pages. But what I would like to know, if I can go back to them and say, when you did this, and I understand you considered everyone, was there any statistical analysis in terms of, okay, we only had 5 cases across the Commonwealth in 5 years, so let's not create another subcategory.
Right.
Did that happen?
That did, Judge. And in
what
fact,
was the cutoff?
Yeah, I think the cutoff was 25 cases over 3 years, right? Yeah. So when we were doing
Go ahead.
Oh, go ahead.
No,
please.
I was going to say, I don't want to jump ahead, but wouldn't that be like 0.0001 or something of the cases within the system?
Yeah, it would be very small. And look, if the commission decided, if it's less than 50 cases or less than whatever the threshold is, we just default to the omnibus score. That would be fine. But what generally happens is there's a case that makes the news, or there's certain circumstances where there's a feeling by the commission or by the public that we need something different for that. And that gets to this subcategorization, like, oh, because there was X, because it was domestic violence, or because it was a really young, a minor or a vulnerable victim, there's sort of focus on that, and then the commission acts on that. But we can do whatever the commission decides in terms of how many specific assignments you want.
Why did you pick that number?
We were trying to get it exactly what your point was, which was when we were preparing these OGS assignments, we were trying to find the median sentence as the typical sentence, because the guidelines are usually built around what's the typical sentence. So we use 0 prior record score, no enhancements. We just looked at sort of pure cases, and we looked at all the offenses that had at least 50 values. And the reason for that is when you had smaller numbers, the median might not have meant much, because you might have been all over the board. So there was, the numbers were spread everywhere, and the median was not as powerful or helpful as if you had a bigger number and you saw sort of this central tendency, there was a lot of grouping around the middle, around the median. So that's why 50 was the number. We could have used 25 and we could have used 100, I guess, but that's what fit for at least the analysis to come up with exactly what you're talking about. Thanks, Judge. So let me hit a couple of other areas just generally under the offense gravity score that that we've always had special rules for, and we're trying to sort of codify this just to keep it simple and automate things. So the first is for inchoate offenses. And the general rule the commission has had is if there's an inchoate to a felony 1 offense, the OGS is 1 point less. That's been a rule we've had for years, and it goes back to when inchoates to felony ones for felony twos. The commission purposely decided at that point to retain that 1 point drop in the OGS assignment, even though the grade is now the same. They're felony ones. So the commission can revisit that, but it has been a rule that we've had now for, 30 years as far as a 1 point reduction for inchoates to felony one offense. So that's in place, and that's found in the section. We have a general policy that says an inchoate to a drug offense carries the same weight as a completed offense. And we have, trying to think if there's some other exceptions here. And if it's less than a felony one, the inchoate's the same as the completed offense. Yeah.
Mark, quick question, just to to piggyback off of Judge's question here. When you looked at the data initially to determine what the average ranges were for the different sentences, and I'm sure we covered this at some point along the way, probably multiple times, but to your recollection, were there, if you recall, if you have this somewhere, what OGSs that are currently in existence resulted in outcomes that were vastly different than the average sentences? Do you recall that?
Well, it's not so much the OGS assignment. It has more to do with what the recommendation is for the OGS.
So the recommended guidelines.
Yeah. So let me give you two examples. If you think about lower OGSs, first, that's where all the volume is, like 1 to 5, 1 to 6, the county jail, county probation, that's where there's big numbers. But if you look at a lot of the recommendations there, especially under the current guidelines, you can do no wrong, right? Because the guidelines cover everything possible. So you can't depart. You can't, even guilt without further penalty is like restorative sanction. So it's okay. So you can't do anything down there that is outside of the guidelines. And then you go up to level 5, where we have serious and violent offenders. And partly because of legislation, partly because of public comment, for some of those offenses, we have substantially high sentence recommendations. And the tendency is to give lower sentences than what is recommended. Maybe it's because of negotiated pleas. There's fewer cases up there, right? And there are cases that more often would go to trial, and maybe there would be some benefit to negotiating, and one of the trade-offs might be a lower sentence. But also, when you get up to some of those areas, we include the statutory limit, the highest minimum sentence. So you can't go any higher than that. You can only go down. So that's just like an artifact of how the guidelines are set up, that the only place where, you can really start to look at like the movement back and forth is about, the middle, maybe from, 7 to 9 or something like that. And I don't want to, there's a lot of, you can learn a lot about where sentences fall, even if they're in the guidelines or legal sentences.
And if I recall, wasn't third-degree murder one that had a large
it's all over the place
disparity in sentence?
And we're going to talk about that at the end of today as one of the example offenses, because, and the judge and I have talked about this. I've talked to a lot of people about this. In fact, just last week with a class at Duquesne Law, Judge Bernstein and I and others discussed this whole thing about, murder 3 is just this default category, and you have effectively murder 1 cases, and you have effectively voluntary manslaughter case, and you get everything in between. And when we look at the 0 prior record score, I think I looked at the numbers, and like in a typical year, we might have, several hundred murder 3s reported to us. And then if you look at 0 prior record score, might be 50 or so. So when we just looked at the 0 prior record score murder 3s, we found probation, and we found 240-month minimum sentence. And the most common was 240 months. It was about a quarter of the cases. Well, we saw 120, we saw 180. I think the median was 144. But our sentence recommendation right now starts at 72 months and goes up to 240 months,
Mhm.
statutory limit. So we give like everything. And one of the discussions we'll have is, as a starting point, are there ways to either redirect that because we have narrower ranges now, and what's the right OGS? And are there ways where you could subcategorize it, where you could say, when these circumstances are present, that warrants something lower as a typical OGS assignment, and in these circumstances, higher. And it may not, maybe we won't find that, perfect answer, but that's what we're trying to look for, because we have more OGSs that are narrower to choose from, and we'll have to make a decision about where to plug it in. And it'd be great if we could have multiple options that reflect something that you're seeing in the field, but it's going to be difficult.
Thank you. That recap was
Right.
helpful. I appreciate
Thanks.
it.
You bet. So moving away from inchoates and moving to the next, which is two types of circumstances where we have offenses linked to other offenses. So if you think about ethnic intimidation, conviction for ethnic intimidation is related to conviction for some underlying or target offense. And the grade of ethnic intimidation is 1 grade higher than the object offense, and the OGS is 1 point higher. So we have that in place, and we use that same sort of mechanism to do assignments for terrorism and eco-terrorism and other offenses that are sort of built that way. So we have a category in the guidelines that just sort of connotes that. And it says, here's what we do for these, but if the General Assembly next week creates a new offense that has that same kind of formula, here's how the OGS is determined. And then we have other offenses that are linked to other conviction offenses, and they carry the same classification, the same OGS. So those are things like convictions for obstruction of justice or unlawful contact with minors, where we say this offense is equal to that offense. And so whatever the OGS for that offense is, it applies to this offense. So that's a general policy we have that we've retained in this set of guidelines. When we get to violations of the Controlled Substance Act, so drug acts, the only change there from what we have in place right now is the Commission's discussion of applying to drug offenses what we apply to all other offenses, which is when there's an increase in the grade or the statutory max, we increase the OGS. So we have historically had a single OGS assignment for, say, A30 under the Drug Act, PWID. But under the proposal, we increase the OGS assignment if it's a second or subsequent offense where the maximum penalty doubles, or if it's trafficking to minors where the penalty doubles. So we increase the OGS assignment. And because we'd be doing that, we would then not take into account in the prior record score that underlying PWID offense. So that's consistent with how we deal with all other offenses, but we had not done that with drug offenses, and this would include that as our policy. Yeah, Judge.
Mark, for just for PWIs, that you're going to
For
incorporate-
PWI, also for the A12 and A14, where you have that provision for the doubling. So I think it's A12 and A14, but it may be 1 for one and 1 for
so
the
if the
other.
person has it's their second PWI,
Mhm.
they would not, their prior record score would be
0 if that was it. If they had 3, then one of them would count. It's just the first that's used to elevate the OGS does not count, which is what we do for other offenses where you have a prior offense moving up the grade of the
well, I
subsequent
think for
offense.
retail theft like that, I know we do that.
Right. But
But PWI doesn't, it's not really, I mean, what increases with the PWI? The max.
the max, it doubles. So you move from like 15 years to 30 years for a second or subsequent, or for, dealing to minors. delivery to minors. And so again, we treated them all the same. Now, what we would do, and this is sort of an offset, right? Because although you're increasing the OGS, that offsets the use of using in the prior record score. So there's some trade-off there,
Is it
but
an equal trade or?
it depends. It depends what the doubling is, and it depends how high the increase is. But the thing is, it's consistent with how we deal with all other offenses. So
Except we've
so
never done it before.
what's that?
Except we've never done it before for PWI.
We haven't done it before. That's
Right.
right. But there have been concerns because remember, it's we're talking about this only when it contributes to the increase. So if you have someone who has 2 prior PWIs, then only one of them is not counted in the prior record score. The other one is. And what we're doing is we're providing a higher starting point because of the grade of the offense. So, I mean, we can look at examples to see
just
if
gonna
that
say,
makes sense or not.
Did we
but
run examples of that?
we did, and it sort of breaks even, at least at the base level, right?
Okay.
When you're just doing the initial trade-off. But when you then start building in the other priors, and you are starting at a higher level because the maximum penalty is higher, it provides for more in terms of the prior record score or enhancement. So, but we can look at those things. But that's just one thing that we talked about before in terms of when we were talking about drug offenses, there was encouragement to increase the OGS when it's a second or subsequent offense.
Gotcha.
And we can do a double counting if you want, in terms of you count it in the prior record score and you count it in the OGS increase. But that's been another general policy the commission had against double counting.
And for the other offenses, we don't double.
Right. That's correct. If there's basically a rule that says if the previous offense was used to elevate the grade of the offense and therefore the OGS,
Right.
then it's not included in the prior record score.
I just didn't remember. I guess we probably discussed this in the summer last year.
Well, I think we did when we were going through all the drug recommendations. Yeah. We've discussed a lot though. So, okay, let me move on to some of the other issues of the offense gravity score. I think the last one of substance is the omnibus offense gravity score. So that's, as we talked before, that's the default. If an offense does not have an OGS assignment, we look at the grade of the offense and we use that as the default assignment. We've had this in place forever. And we would be more reliant on this if we followed through with what we were discussing earlier, where we had fewer individual assignments and we just relied on the omnibus. So, but that's there. The difference here is we realigned because we have a new 36-point scale. So the OGS values have changed to reflect that. And we've talked about that before. And I think that covers most of the preliminary provisions regarding the offense gravity score. So unless there's any more questions on that, we'll move to the next section, which is the enhancements section. So under enhancements, and we've spent a lot of time talking about this over the years, we currently have something like 20 enhancements in the guidelines, most of those required by statute. Some of those are specific to certain offenses like robbery of a motor vehicle or home invasion burglary. Some of them are very broad, like deadly weapon enhancement. It applies to any offense for which a deadly weapon is not an element of the crime. And then there's a lot of stuff sort of in between. And then some of the enhancements are very specific under the statute, like for abuse of children, child pornography. There's 2 or 3 different factors we have to take into account in that. And then for other things, they're very broad. So we have a lot of enhancements. One way of dealing with enhancements is to just build it into the OGS assignment. So that's an example of that subcategorization. As an example, For murder 3, we are required to have an enhancement if the victim is less than 13 years of age. And so since it's specific to murder 3, what we can do is with our OGS assignments, we can assign a baseline value for murder 3. And then when murder 3 involves a victim less than 13, we can increase the OGS by 1 or 2 points. So that's a way of accommodating that enhancement and just building it into the OGS assignment as a subcategorization. But there are many times where it's just not that simple, like I said, with deadly weapon enhancement. And so what the commission is recommending for deadly weapon enhancement is that if there is a weapon used or possessed during the commission of the crime, there's a 2-step increase in the OGS. And if there is a weapon used during the commission of crime, there's a 3-step increase in the OGS. And this tracks pretty closely to our current enhancement that we have in place. It's just that presently we have separate matrices for possessed and used deadly weapon enhancement. So this would just, instead of having all of that effort there, this would just have a calculation of it adding 2 or 3 points to the OGS. And many of the other enhancements work like that. So as I said before, what we envision is we take all of the enhancements, we do either a direct assignment through a subcategorization, or we identify the number of points that are impacted, and then we provide that as a list, as a table, and then separately in SGS Web, we just build that in as a check the box calculate.
Quick question, Mark. Well, I don't know if it's a quick question. I'll try.
Right.
So I remember when I first became an assistant district attorney, right? And I had the binder,
Mm-hmm.
and we would go through the binder and we would, figure it out from there
Right.
in court, like on the
Right.
fly. And when I'm listening to discussion of enhancement and the assignment +2 +3, it's sometimes hard to conceptualize it because it's relative based on the new amount of OGS categories. Does that
Mhm.
make sense?
Right.
And so with that in mind, again, I'm sure this was discussed, and like you
Mhm.
said, there was a lot discussed
Yeah.
and a lot of time here. But were those decisions made based on getting to a certain place with regard to the sentence, or was it just based on whether it should be 2 or 3?
Right. Yeah, a great question. What we tried to do as much as possible. Well, let me back up. One of the reasons we've gone to 30 general categories of OGS is that if you look at our current matrix with 14 categories, there's a lot of inconsistency about how you increase from one to the other. So there are times when we say under the current guidelines with enhancements, increase by 1 OGS. But in some cases, you're going from RS to 6 to RS to 9. And in other cases, you're going from 12 to 24 to 24 to 36. So there are some sort of inconsistent things. And you're expecting some, for more violent offenses, there's going to be a bigger increase for less violent. But right now, it's inconsistent and it's overlapping. And so under the new matrix, the focus based on JRI 2 and a lot of other recommendations is to have more consistent categories that are focused to specific dispositions, probation versus jail versus prison, and then that the step-ups are more consistent and sort of gradual. And so with that in mind, the idea of using +1, +2, +3 gives you more regular increases than the current system. And then using that, what we could do, because it's more regular, we could look at what is the recommended increase for deadly weapon used right now? How many months is it? How does it compare for OGS 9 versus OGS 3? And then we could figure out how many steps are sort of the equivalent of that. And it's not perfect, but it's way better and more consistent. And so we tried to replicate the impact of the current enhancements when we built the number of steps. But that's also an open issue for the commission. You could look at it and say, yeah, it might have always been that, but it shouldn't be. And, we'd prefer this. And this gives you a more systematic way of doing what you think is appropriate. Right. Thanks. So, so at page 13 through till page whatever, I think it's page 17 are all of the current enhancements. And the difference in these tables is that we have tried to provide the comparable, sort of translated into the new guidelines. So you should be able to look at those. And then in table, find my table number or letter, in table C, I believe it is. Yeah, table C is the listing of those enhancements. It's sort of the cheat sheet. So you can just look at table C and see the sentencing factor and the number of points for the OGS increase that applies. Now there's one issue that I didn't highlight in the draft, and Brian, could you go to page 14 under deadly weapon enhancement? So one of the things we talked about before but never resolved dealt with the deadly weapon enhancement. And the deadly weapon enhancement applies, as I said before, across the board, and it is supposed to be considered and applied every time there's an offense committed where a deadly weapon is not an element of the crime, but a deadly weapon is present. So it should be happening a lot. When we did the study on mandatory minimums and a couple of the other studies, what we found was the deadly weapon enhancement was not applied in a lot of circumstances where all of the factors determined that it should be applied. So this is a difference between the court exercising discretion and saying, okay, I applied it, but I think that's too harsh or not appropriate, and I'm going to depart, or I'm going to mitigate, or I'm going to aggravate. Difference between that and not even considering it, not building it in. So the deadly weapon enhancement is supposed to be built in based on the determination that that factor was present. So one of the reasons we're trying to automate enhancements, and it's not just this enhancement, it's the sexual abuse of children enhancement, where we just had a task force, and the study from the task force was the same thing, that there were many circumstances where the enhancement that the commission has and was mandated to have should have applied, and it was not applied by the court. So we're trying to, again, simplify this, but also automate it so that it is built into the consideration by the court. And then the court can depart because the court has discretion, but it's supposed to be built in. And so one of the offenses that was highlighted during discussions of enhancements, and especially deadly weapon enhancement, was murder 3. And if you think about the sentence recommendations we have for murder 3 presently, and then assume that you're going to be building the enhancement into it, there were questions raised about whether it is appropriate or whether the commission should consider excluding the deadly weapon enhancement from murder 3, or in its place, subcategorizing murder 3 that addresses certain types of offenses or certain violence. So for instance, if there was a determination that a firearm is different than a knife, is different than other deadly weapon implements, that might be an example where under the subcategorization for murder 3, you could indicate that. So instead of a deadly weapon enhancement, there might be an enhancement related, or a subcategorization related to the type of weapon or the nature of, of the crime or other kind of factors. So I just wanted to raise the issue because it was raised before about whether we should exclude murder 3 or homicide generally from the deadly weapon enhancement, and then how we move with that. Yes.
Yeah, thanks, Mark. Could you just, you had talked about how there was a trend where there are many cases where this enhancement should have been used or should have been considered,
Mhm.
but it wasn't. Could you just speak more to the nature of the kind of cases that we're talking about where,
Sure.
where that was missed?
Sure. So when we were studying mandatories, one of the or not just mandatories, when we were studying the Uniform Firearms Act, HR 111, we were required to look at offenses that were charged and sentence recommendations and sentences imposed. And when we were doing that analysis, we're looking at all of the information before the court and all of the conviction offenses in the incident. And there were many times when there was a conviction offense that also included a conviction for violation of the Uniform Firearms Act or illegal possession of a firearm, for which the lead count, which might have been, you pick it, an assault, a burglary, something like that, that did not have the deadly weapon enhancement. So within the incident, there was a finding, beyond a reasonable doubt that the person had possessed a weapon during the commission of the crime. But on the other offenses within the incident, there was no deadly weapon enhancement, and they were not offenses for which a deadly weapon was an element of the crime. So that's the kind of analysis we were able to do that identified a pretty substantial gap in serious cases where the deadly weapon enhancement was not applied, but there was proof that there was a weapon in the incident. And then, as I mentioned, the task force about sexual abuse of children, about child pornography, there was our analysis, but also analysis by PCCD and others, where they were looking at the same thing about cases that they had in terms of where there were a number of images, other things like that, that the enhancement should have applied, and it was not applied in, I believe, in a majority of the cases. And I think tomorrow we have an extract from that report, but it was a real concern. The commission, the General Assembly enacted and required an enhancement. The commission worked through to develop one. We put it in place. We do training about it, and it was just it's like disregarded. So part of it is we have to make sure we're doing a good job to make it easy to implement, that people are aware of it and considering it and building it in. And that's why this automation helps. But also, people in the field have to apply it then. And that's an important factor.
Thank you.
Quick question, Mark. So when I think about murder cases, let's say first degree and third degree are charged.
Mm-hmm.
First degree, found guilty of first degree, the third doesn't matter.
Right.
So when I try to think of the typical third degree murder only cases,
Mhm.
from my experience, I mean, those, beatings that may result in a murder, if
Mhm.
someone wouldn't have died, they would have been aggravated assault, things of that nature. Do you anywhere have, and I'm sure my guess is you probably do,
Yeah,
somewhere a breakdown of all of the third degree murder only cases and what typically, whether or not they're deadly weapon used cases versus not? Does that make sense?
Yeah, it does. And I'm not sure that we have those specific details, but we've been trying to do exactly that kind of analysis. Like I
Mhm.
said, we've identified the 50 or whatever cases in the sample we had that had a 0 prior record score. So we were just looking at those. And then we looked at the distribution of sentences. And as I said, they're all over the map. And when we look at these were all cases where there was no deadly weapon enhancement, because one of the sort of screening criteria was to remove mandatories and enhancements. So we were looking at like pure 0 prior record score, murder 3 conviction.
Mm-hmm.
And so none of these had the deadly weapon enhancement. And so you can look at that and see it's all over the page. Now we could do another round of that where we're looking at, if we can find evidence of like what was the weapon, was there a weapon, was it possessed or used, and so
And just so you know, the reason I ask that is certainly not to create more work. It's asking it through the lens of, is it actually a problem?
Yeah.
If that makes sense. Or is
Right.
it, because again, if there's a deadly weapon used, I know in my experience, and someone dies.
Yeah.
Like it's typically first degree murder
Right.
or
Right.
second under the right circumstances.
Yeah. Judge?
Trying to decide how to say this tactfully. But was there ever any consideration given to taking out the cases from Philadelphia? Because I think we have a bulk of the murder cases.
Sure do.
And I know from professional and personal experience that there's a wide range of negotiation.
Mhm.
And that has been ongoing. And I've been doing this long enough. I remember when third degree was, for some of you, it was only 10 years.
Right.
And I
That's
was
right,
a
Judge.
defense attorney then,
Yep.
statutory max. And I was one of those people pushing to increase the maximum because I couldn't get pleas for my client from first because everybody thought you got charged with third and pick 12 and a half was insufficient for third.
Right.
But I mean, I think I would be remiss in not pointing out that third degree, and I think this is where some of the problem becomes, is a negotiation frequently where there's a recognition that the person, the doer, does not deserve life imprisonment.
Right.
Therefore, you're negotiating it down to third. Now, that puts the judges in a difficult
Yeah.
position because equitably, we're all in the courtroom knowing that this is a third degree case that has been negotiated down, but we're confined by the statutory guidelines. So my question really is, I would be curious, and I know we have a bulk of the homicides. If you took Philly out, is it that much of a problem? I mean, the deadly weapon enhancement gets applied by us, and then we just say, negotiated plea.
Yeah. Yeah.
So
Judge, I think
I
that-
don't, I mean, maybe
Yeah.
that's asking too much because
Oh, no.
it may not be a problem anywhere else.
No, I think so. Here's the thing: we did, and we could look at it for murder 3 specifically, but we certainly did when we were doing the analysis. Looked at Philly separately from the rest of the Commonwealth. Looked at urban counties, so that meant we threw in Allegheny County and maybe the suburban counties. So we did, urban, rural. We did a lot of other things, and believe it or not, I mean, there's certainly exceptions, but Philly did not look that different than some of the other counties. But we'd have to look specifically at homicides, and that might be different in Philly. But what we see, the question is, or the issue is, not necessarily just on the leniency side, like this is a negotiated plea and there's that. We also see it on a quarter of the cases got 240 months as a minimum term. So the longest minimum term for a murder 3, 0 prior record score. So that might be the negotiated murder 1, right? It could be a lot of stuff, but we'll show you that a little bit later. And again, we're sort of agnostic in terms of what to do, except that if we have these narrower ranges and more choices, and right now we say murder 3 is 72 to 240, and now we're trying to come up with, fitting it into some kind of different kind of thing. We have to either adjust those ranges and think differently about that, and whether that applies to similar offenses like rape of a child less than 13, serious bodily injury that has a high statutory max as well. So we have to sort of think, what does the matrix look like for those really violent, serious offenses? And how does murder 3 fit into that? Or can you subcategorize? Are there things you could take into account that would make sense to have different assignments?
And I agree with that wholeheartedly, except I'm saying when the negotiations are such that you're avoiding life imprisonment
Yeah.
without parole, no subcategory you're going to come up with will cover that. Because
Right.
the facts the facts can look similar
Mhm.
to any others. That's all. And maybe
Right.
when we get into it more detail, I can see it. But that's my initial reaction
Exactly.
to it is it really isn't going to solve what, and I'm not saying it's a problem as a judge.
Sure.
I have a responsibility and I'm going to do what the case is going to do. But I think that may be contributing to, but you're saying it doesn't. So I'm getting educated.
and I
That's
don't-
not making a
I mean,
difference.
in many of the other offenses, we expected to find more differences and we didn't. The exception, the one big exception was drug offenses, where we saw substantial differences between Philadelphia and the rest of the state. And it was in sort of 2 directions. One is the nature of the offending, very large quantities of drugs. And then in other parts of the state, there were, departures above the guidelines. In Philly, it was departures below the guidelines. So drugs just look different, but many of the other offenses look similar. So
Mark, I think we talked about this before with
We
the
did.
third degree murder, and you and I have talked about it for probably 15 years.
at least
Um,
maybe 25
maybe
years,
25.
but just saying.
and Judge McDermott's totally right. I was a prosecutor at the time doing homicide trials when the DAs lobbied the legislature
Sure.
under Governor Ridge, then I think to change it from 10 to 20, and defense attorneys too, because as a prosecutor, you'd say to that victim's family, that guy's going to get 10 to 20, he'll be out in 10. And the mom's looking at you like, what do you mean? My son's dead.
Right.
So I think that single-handedly took away a lot of murder trials.
Mhm.
In Harrisburg, I think a lot of third-class counties, maybe York's a little different from what Dave was saying, but Harrisburg, York, Lancaster, those types, a lot of our murder cases are that. Is it first? Is it third? It's a shooting on the street corner. Everybody's involved in something they shouldn't be involved in.
Right.
And most of our third-degree murders in Dauphin County are with a gun.
Right.
Now, occasionally you might have the shaken baby type third-degree murder.
Right.
Yeah,
Yeah.
the use of head drama, the things like that. But I just think it's so hard to subcategorize. There are a ton of plea agreements for 20
Yeah.
to 40 or 15 to 30,
Right.
that you're going to have. But then there are some of the third-degree murders, where the jury comes back, they're like, it was one shot. It
Right.
wasn't first, they'll find him guilty of third. So that I think it's so fact specific.
And I
You
think
might have to
we've
keep it
heard
a
that.
separate category.
Yeah, I think we've
I
heard
know
that,
you
and,
don't like
that's and so and we'll get into this deeper. But I'm really glad for this discussion because we do need you need to make a decision about just how do you handle this offense. And the thing is, if you look at the sort of the options available on a 30-point scale, forget about the murder 1 and 2, but the options available on a 30-point scale. What we've done presently in the recommendation is substantially increase the base of the recommendation for murder 3 because the median is 144 months and the most common value was 240 months. So 72 months as the base of the range is way low, except that we know there's tons of cases where that made a lot of sense and even less than that because of the circumstances. So then it gets to, if you just have to find a number, what's the right number to use as the starting point where you recognize there's going to be aggravation, mitigation, departures, and we're trying to get better reasons for why that is. But it's like, just like the problem right now is you go 72 to 240 and it's all standard range. We don't learn anything about it, and so we're trying to figure out what should that common starting point be. Courts exercise broad discretion in that area, and then we try to get better information for the future of saying maybe there is a subcategory here that we did, in discussions, and I've had quite a few discussions about this over the years. There seems to be, a couple of categories of offenses that seem to continue to come up, like domestic violence. But domestic violence comes up two different ways. It's like, what if the victim has been repeatedly abused? And this is, it's an imperfect defense, but, she ends up killing the guy. What about that? And then what about if the defendant has been continually abusing the victim and finally kills the victim? So you get, even DV ends up being like two different recommendations in terms of like who's at fault or, anyhow. So we've heard some common things, and I don't know if we can do anything with it, but that'll be, coming attractions. That'll be before dinner, before 5 o'clock. We will return to this, and I'll be awaiting your answer then. So with that, let me just move on because I know we have a lot to cover. So we've talked about the enhancement. We'll come back to just with deadly weapon enhancement, whether that should apply to homicide, to murder 3, other things like that, or if there's anything differently that we do about that. But that was one of the slight modifications to the existing guidelines. The other thing that's highlighted in enhancements, and this is at page 16, is the sexual abuse of children. As I said, there was a task force. There were concerns about the underutilization of the enhancement as it exists. And there has been a recommendation for a much broader engagement between the courts, the commission, DAs, others to try to really, promote broader education about this issue and try to reach higher compliance. So we can look at these specific enhancements later, but again, let me just keep moving on. The final enhancement that I was going to mention or that I highlighted is at page 17. And I think this is a new enhancement. It seems every couple of years there are substantial changes to the DUI laws, and this year was no exception. And so one of the new provisions among many of the DUI statute is a real focus on repeat offending, subsequent offending, and the use of consecutive sentences in certain circumstances. And this includes requiring the commission to create an enhancement in the guidelines when there is a fifth or subsequent DUI. And so what the staff has recommended, because it fits the model that we've developed for the OGS assignments for DUI, is that we would increase the OGS by 1 point when you got to that fifth or subsequent offense. Judge? I think that's a lifetime, isn't it? I believe. Oh, it is. Okay. Right. Okay. So I'm sorry. So for purpose of the mandatory and the grading of the offense, it's a 10-year look back. And as Ron was saying, the thing is the guidelines don't have a look back period unless we adapt the lapsing provision, and that'll be another discussion. So anyhow, but I just wanted to highlight the DUI for the prospect that there would be an enhancement there because of the repeat offending. And then moving down under mandatory sentencing provisions, again, we've had this kind of information in the guidelines before, but what's notable and different is that we've established sort of a separate table where we really, I think, embrace the DUI mandatories, use those as our starting point, because you have to impose the mandatory and then build from that based on the grade of the offense. I think in the end, I think it works better. It's more consistent. And as I said, we then sort of attribute that to voting under the influence, since there are mandatory provisions that sort of operate the same way. So that's it for OGS. We'll come back to looking at specific offenses towards the end, but just any final thoughts or comments? Okay, if you thought that was fun, we're now moving to prior record score, which is a substantial change from what we have. I mean, the commission has always, and is required to include consideration of prior convictions and certain prior juvenile adjudications. There have been concerns throughout this process, and remember, we've been working on this since 2014, but there have been concerns about the sort of the heft of the prior record score in terms of the sentence recommendation. And we've talked about this before. In certain circumstances, the prior record score can increase by a factor of 9, the sentence recommendation. So the idea was to try to come up with ranges and use a prior record score, with the exception of repeat violent offenders, those subject to basically to 3 strikes, except for those types of circumstances, trying to think in terms of the prior record score doing no more than doubling the base recommendation. So that's sort of a rule of thumb. It's generally followed in the recommendations we have, but as I said, the exception is REVOC, or repeat violent offender. So the prior record score 4 category, where we include the statutory limit in all cases. as an upper range. So that gives quite a bit of latitude to the court for those violent and repeat cases. So for prior record score, this starts on page 19. Instead of having 8 prior record score categories, we have 5 prior record score categories. A couple of like distinctions. One is 0 is effectively a pure 0. In the past, you could get into 0 with a 1 prior misdemeanor. Now 0 is 0. As I said, we've tried to come up with what we think is actually a simpler way to approach the prior record score that we think responsibly takes into account the seriousness of a number of prior convictions. That's always been sort of a hallmark of the prior record score, although we did it in a pretty complicated way. But we always sort of tried to identify and tried to give weight to the most serious prior convictions or juvenile adjudications. And we gave those, 4 points in the prior record score or 3 points. We gave, we gave a lot of weight to the seriousness of the prior convictions or adjudications. And then we took into account the number. But one of the problems we found when we sort of moved from that individual consideration of those priors and tried to look at how does that get you into a prior record score category is that we were often mixing apples and oranges. Think about prior record score 4. You could have someone with a prior violent offense like rape or murder 3, and you could have someone with 4 misdemeanor 3 offenses, right? 4 1-point offenses. And so you're putting in one category 2, very different people. And there were, plenty of other instances, and nothing's going to be perfect. But what the commission staff through the various advisory committees that we met with tried to get to was simplifying this by getting rid of like some what might be artificial constructs of like looking at a judicial proceeding, finding the most serious offense of that, counting other offenses if it was consecutive, and then counting all of the proceedings, and then adding the numbers together, and then whatever. It's complicated. And so the idea under this revised approach is to just look at all prior convictions and adjudications and identifying the most serious offense, and then determine if that's a singular offense at that level, at that seriousness, or if there were multiple. So that's the analysis. And so based on that, we come up with the sort of simpler categories. And
Actually, Mark, just a quick
Yes,
question.
please.
Sorry. Could you speak just a little bit more, and maybe we'll get into this, but so it was 8 categories before, and now it's 5. Just how the number of 5 categories was landed on.
Sure. So I think we landed on 4 initially, and then we added 1. But so if we start with where we were under the old guide or are under the current guidelines with 8 categories, the idea was there would be some caps along the way. So effectively, you could not get beyond 3 in the prior record score with just misdemeanor offenses. And then you generally could not get beyond 5 in the prior record score without felony 1 or felony 2 offense. And then we had 2 special categories, RFL, repeat felony 1 and felony 2 offenders, which was defined as someone with at least 6 points in the prior record score based on felony 1s and felony 2s. And you'd have to know what the prior specific felony 1s and felony 2s are because they had different weights, somewhere between 2 and 4 points. And then we had a final category, REVOC, repeat violent offender category. And that was the commission's alternative to 3 strikes. If you think about the 3 strikes law in Pennsylvania, you have a person with a current conviction offense for a crime of violence, and the person has 2 prior convictions for a crime of violence. And under the guidelines, a crime of violence has 4 points. So effectively, you have 8 points in the prior record score, and your current offense is a crime of violence. The reason why we created that category and thought it was actually meaningful was under the statute, if the DA actually gave notice and moved under the 3-strike statute, the statutory max is life. And so by building it into the guidelines, there was an alternative to the use of the mandatory that would be constrained by the statutory max for the offense and the guideline recommendation, even if the guideline recommendation was the statutory limit, right? So if you had a 40-year max, the highest the sentence recommendations could go is 20 years. You get a 20 to 40. But under the statute, you could get life. And so it was something, it was different, and it was an alternative to the mandatory. So that's the profile we have in place right now. What the commission wanted to do, or at least the discussions we've had, was try to simplify it in terms of how do you even determine it. So let's just focus on the grade of the offense and not so much on which offense has how many points. So less math. Let's also just sort of focus on that most serious prior offense being sort of the one we want to focus on and determine how many other priors look like that in terms of seriousness, same sort of offense group. And then we wanted to make sure that the overall impact of the prior record score generally did not exceed 2 times the base recommendation. And that's built around a concept that we've always talked about and never did, which was that the focus of sentencing should be on the current conviction offense. I mean, there's going to be a price for prior offenses, prior convictions. It could be because of retribution, it could be because of risk, but there's going to be something because of priors, and we're required to consider that in our guidelines. But 9 times maybe is not necessary. And so the research out there and that sort of the logic was if we're saying the current conviction offense is the most serious part of sentencing, then we should sort of focus on that being where we apply the penalty, and that the prior record score can be an enhancer, but not, generally not more than double. And the big exception is if you're a repeat violent offender, we sort of take the lid off and we say to the court, this may be different, individualized sentencing. We're going to give you the latitude to do what you might think is appropriate given repeat violent offending, repeat crimes of violence. So it doesn't even matter under the guidelines as we have it proposed, whether the current conviction offense is a violent offense. The thing is, you have 2 prior crimes of violence and you're before the court for sentencing. We should give the court latitude to give whatever, up to the statutory max, whatever the court with a General Assembly authorizes. You bet. Yeah, less math is great. So that's the premise of what we're trying to do. And again, I keep talking about this web application that we're working on, but we really do appreciate that all of this is complicated, and computers can be our friend, and in this case, we think some of this can be automated and simplified to a good purpose too, that we're principled in what we're trying to do, but we also can automate it to make it easier on the end user than the court. So the idea is to identify effectively 4 groups of offenses in terms of seriousness. So the top one, the most serious offenses, are the crimes of violence, and those are defined in statute, section 9714G. So under the 3 strikes repeat offender provision, those are the crimes of violence, and they are in the top group, and we treat those differently. The next group down, we initially started with felony 1s and felony 2s. And during public hearings, there were concerns raised, quite a few concerns raised, that there are misdemeanor 1s and felony 3s that sort of are more serious than their classification would reflect. And the 3 categories of those offenses that were raised were offenses against individuals, crimes against individuals when they're F3s or M1s, sex offenses, so Megan's Law offenses when they're F3s or M1s, and violation of the Uniform Firearms Act when an F3 or an M1. And so effectively what we did was we took those three categories of F3s and M1s, and for purposes of the prior record score, we treat them as felony ones and felony twos. So your top category is crimes of violence. Your next category is F1s and F2s, and then those special F3s and M1. So serious violent offenses in that second category, but not crimes of violence. Third category, any remaining felonies, and that would include drug felonies. The fourth category, any remaining misdemeanors. So those are the four categories of prior offenses. So the process then that we're suggesting is when you have someone convicted of a new offense and you're trying to determine the prior record score, you look at any convictions or adjudications prior to that date of offense. You identify which category of offenses is the most serious in that person's prior. And then you determine if there's one or more than one offenses in that category in the priors. And that's how you determine the prior record. You can do it from a rap sheet. You don't have to know about criminal incident. You don't have to know anything except what are all the convictions on the record. And we can automate all of that in state. The problem we would have, and the problem we have right now, is out of state or federal. And so with that, we have rules in place about current equivalent. But keep in mind, if that information is already in our application, we can then hold on to that and use that information. So we can provide a mechanism for automating this, allowing the user to add any new information, and then basically retaining that information for future use. And we could reuse some of what we have already, but we're starting fresh on a lot of it. So that's the approach to this that we're talking about in terms of laying this all out. Now let me talk about two or several other modifications to our current policy. But first, I want to hear from the DA.
Thanks, Mark. Quick question. So for my defense attorney colleagues, again, I go back to my experience in the courtroom. And as the years have gone on, we've automated a lot of this in the New York DA's office. We have case managers that do all this for the attorneys. And oftentimes we have to, as we collaborate with defense counsel, find a just outcome. We obviously, share, in a courtroom, we'll talk to them, we'll show them how we came up with that information. And this may not be a legitimate concern, but I feel obligated to bring it up. Well, considering that defense counsel does not have access to SGS Web, and I would certainly defer to my colleagues on the commission up here that have been in that position, what burden does this put on them with regard to their ability to understand and explain to their clients how the prior record score has come to light? And I only bring that up because, all of us in here who've been doing this for a long time, we often stop and we're like, oh man, what did Mark just say? And again, this might not even be
Staff's just like that.
I mean, this might not even be an issue. I just feel obligated.
No, it's a good point.
To bring that up for discussion. So.
And we've talked about this before. And so here's a couple of things. First, let's not forget our baseline, which is right now they don't have access to that either. And it's a more complicated prior record score strategy right now than what we're proposing. So that's we have to keep in mind our baseline. But more importantly, as we're rebuilding SGS Web, we've talked exactly about that issue. Now, here's the limitation, here's the promise, right? So the limitation is that it's not our decision, not the commission's decision about who can access SGS Web in terms of JNet, because SGS Web is based in JNet. So it's a JNet policy. And and so, public defenders don't have access, but defense attorneys generally don't have access to JNet. So what we talked about as far as this design of the next gen SGS Web is two separate approaches, and we'll have to see which works. Like, first is, can we provide defense attorneys, whether public defenders or otherwise, with effectively a mirror of what we have in our system. So if they can't get into SGS Web, if they can't get into JNet, can we provide them with that information outside of JNet? Is there a mechanism to do that? And we think Christy has been talking to JNet and others, and we think there's a way to do that we could give defense counsel access to that. And maybe it involves some kind of registration system so that we know that the case, that they.
Yeah, I mean, we have a similar capacity with overdose data
Right.
through what's called Blue Guardian, how it pulls information from Odin.
Right.
And it puts it in different categories based on who the viewer is.
Right.
So
So we think there is a way, as we're rebuilding SGS Web, to build in a capacity, and I'm not sure, it won't be exactly the same, but it would be giving them access to the information that they'd want. And that also sort of facilitates just access to the application in the courtroom, on a tablet, things like that. So, there's rules that would have to be put in place, but we see that there's possibility now for that what didn't exist in the past. But separate from that is the idea of trying to make sure that even if you don't have a specific case that you're working for, where we'd want some kind of access control, right? We should have, much easier way to make guidelines generally, like a calculator, available to the public generally, or to anyone working on the fly. You're meeting with a defense attorney and you're trying to negotiate something, and you don't need to know that person's SID, but you need to know, what are the offenses in play right now? What's the prior record score look like? And the two of you can work through issues there. So we've been talking for a long time about having, on whatever platform it is, having some kind of calculator available, some kind of stripped down guideline application available for public use. And so both of those are in the discussions. Tomorrow we'll talk money, but both of those are part of what we're trying to develop, and we're doing that both because of what you raised, which is, just out of fairness, and in negotiating cases, everyone needs to have the same information. But also, if we start going down the path of lapsing of offenses, we're really talking about putting maybe some extra burden on the defense in terms of identifying those cases that qualify for lapsing. And so all the more reason to make sure they have access to information. And if we can't do it through JNet, we'll develop a workaround for purposes of our application. Judge?
And we may have discussed this, but if we get through all of this, we hit and we adopt an 8th edition, is there going to be a gap of time from adoption to implementation to allow for training? And the second prong of that is, we want lawyers trained on it, we want judges trained on it. Is there any way we can require, and if we can't require, can we link funding to counties to the training? Because this is a lot.
Yeah.
So I just keep thinking, we're here, going to get over to here, but in the interim, while we're doing that, what does that look like, and how do we get everybody trained?
Yeah. Well, that probably explains why I've been pushing to try to get these things out for public hearings and adopted. Because you're right, we can't even start that process until we know what we're trying to sell or we're trying to educate on it, right? So we need at some point to, call the question. So to approve for purpose of public hearings and adopt. And so, let's talk perfect case scenario. We go through this tomorrow. We approve for purpose of publication the various guidelines we have, and we publish those in January, and we have public hearings in February and March. And at the March meeting, we adopt and submit to the General Assembly. That would be the time at which we would then be able to start all of the training you've talked about, with the idea of anticipating a January 1st, 2024 implementation, and spending all of next year building the application so that it does this stuff and we're training on that. Now, it could be that, and I think there's probably a majority of staff that would support this, that, even if we do that timeline, we push off the implementation until June, 30 or July 1st of 2024, so that there's more time available for training and education. But, the bottom line is just moving us along, because we've been working on it since 2014, and we either have to move it forward or just close the deal. It's just so you're absolutely right. There's a lot of those important things. One thing though, that we're in the weeds here, and I get that, but one of the reasons why automation is such an important part of this effort is that we do need to automate this process. We do need users to be able to use an application with ease to do this. And I think, I know I fall into this, and I think others do, that we sometimes think of, our typical procedures and our typical requirements as always in place, and that's always going to be the way we do things. And I think we have to really think about how we take full advantage of automating this, so that users aren't, that it's not more complicated than it needs to be. So this whole effort, it's been not great in terms of all the detail, but we have to do these details so that we can come up with a framework and an application that's easy to automate and use by users.
And if I'm not mistaken, I understand what you're saying is a lot of what we muck through, they're not going to have to, because we're coming out with a nice
Right.
polished finished product. Nevertheless, that final product is very different than
It
what we
is,
have now.
absolutely.
And that's all I was wondering, which I
Yep.
think you answered the question, but you don't mind in my second half, and then I'll be quiet. I'll try, is how do you get people to trainings? We can
Yeah.
offer them, but we can't mandate them. But I think it's a kind of training that should be mandated in some manner. So I'm just
Right.
throwing that out there at this point, not
Well, we
asking
can-
for an answer.
As we do right now, and we can continue to do this, we provide free CLE and CJE credits. So for individuals that, that having those credits is important, we can, we provide opportunities for that, and we don't charge for that. So I think that can be helpful in terms of, paying for people to, incentivize in some way. We can certainly look at that, but I'm more concerned on paying to have this all done. So yeah. Yeah. Got it. I know, Judge, and then I know Attorney Marsico has a
Oh,
question.
okay. I just wanted to jump in real quick, because I have to give the commission kudos for in the past, because I've been around through enough of these transitions. And I have to say, the training has never been an issue in an area like Philadelphia. These sessions have been offered for the court staff, sessions have been offered for the attorneys. And I just want to point out, I think we're in a particular situation now where, unlike the past, where maybe you could not have as many across the Commonwealth, we've all been conditioned for online in Zoom. And I think this is one of those situations where it will become, I think, less costly
Yeah.
to educate more people.
I think you're right, Judge. Thank you. Appreciate that. Attorney Marsico had a question.
Well, and thank you to District Attorney Sunday for raising this on behalf of the bar, the defense bar. But I think you answered my question. I'm just trying to make sure I understand, the way things work right now. Sentencing guidelines are usually provided to us defense attorneys during discovery. And then, I have the worksheet and I look at the worksheet, and if I think something looks off on it, then I'll say something. I say, I don't think this is correct. and then maybe we, the DA and I have a discussion about the guidelines and hopefully come to a, common ground. So, is that going to be, how is this going to be different? I mean, am I, at the defense attorney, am I going to be able to still check the work and say, okay, here's how they made this calculation?
Yeah, as we envision it, and this is part of the, building of the new application. Right now, we import data for purposes of the risk assessment and other reasons. We have an online connection with AOPC and their Common Pleas Case Management System, as well as their MDJ system. And so we're able to harvest information on all of the prior convictions within CPCMS or the MDJ system. And so that's the sort of the first round of data that we have access to. And based on that, if you just think about an individual case, we would be importing all of the prior conviction information available about that individual. And then we could identify, because we'd have the information on the statutory max and other details, we could identify the most serious offense and the number that fit the same category. So many of these things can be automated. As I said, I think the gap right now is that we do not have similar access to information from other states or from the feds, and so or on the juvenile side. But the way we deal with that right now in the guidelines is we have users enter that information and we retain that information in our application. So this would be a first time around, any of that external information could be added, and unless there's new occurrences externally, that could be archived and could be used if that person comes back into the court. So we're going to have a live refresh from CPCMS on the in-state stuff. The thing that would be added is out-of-state. And then based on that information, and this is where I get to, is it a guideline form, is a information report, whatever, you could envision having a list of all the conviction offenses that were reported to us or that were in the database, so that you could, and where we identify the most serious and the number of them, so that you as a defense attorney could verify or question whether that's legitimate. It's one of the reasons we are using court information rather than rap sheet information, because of the underreporting of convictions in rap sheets. Otherwise, rap sheets might have been, an opportunity to consider.
Okay, thank you.
Sure, thank you. So I think we should be taking a break soon. So let me just wrap up a section here about juvenile adjudications and the groups, and then we'll take a break and come back for lapsing. So there's some incentive for you. So this is page 19. And one of the recommendations from the Juvenile Court Judges Commission was increasing the age at which juvenile adjudications are considered in the prior record score from 14 to 16. And the context for this, and this has to do with meetings we had, with the Academic Review Committee and others, was just the general concern about using juvenile adjudications in recommendations in criminal court. And we have the authority to do this. And we've always used 14 as the threshold. And then we limited the offenses to felonies and certain M1 offenses. So we would continue to go with felonies and certain M1 offenses, but this would increase the age 16. Now, the huge exception to this is that any transferred cases that are in criminal court, so direct file cases that are not decertified or certified cases to criminal court, are treated like adult convictions. So all of those offenses will be included, and they'll be included as adult convictions as they are now. This is just removing the 14 and 15-year-olds that are not transferred and are retained in juvenile court for felony and certain misdemeanor one offenses. So that's a recommendation from the Juvenile Court Judges Commission that's incorporated here. There were others that argued we shouldn't include any juvenile adjudications, but our statute's pretty clear that we not only have the authority, but I think the obligation to consider juvenile adjudications. And even with this language and this change, courts may always consider other factors. We talk about that in terms of even arrest information that didn't lead to convictions. I mean, courts have discretion and they can consider factors that are not part of the guidelines. But this, at least for the sort of standard handling of matters, would create a higher threshold of age 16 for juvenile adjudications. So that's a recommendation that is built in at this point. The final things I'll mention just on the prior record score stuff is I think the excluded offenses, because of how we've rebuilt the DUI and BUI OGS assignments, there's even more or greater consideration of the prior conviction offenses in determining the OGS. And for you, all of you who are familiar with the DUI matrix or penalty scale, it's very complicated, and it would be very difficult for a practitioner to determine whether that prior offense contributed to the increase in the grade, or if it was because of the BAC, or it was because it was a school bus, or whatever other kind of factors that go into the calculation. So it seems the most straightforward and appropriate approach is, for purposes of DUI conviction offenses, excluding DUIs in the calculation of the prior record score, because we've captured that in the OGS assignment. But for other offenses, we can use the DUIs in the prior record score. It's just when the DUI is the conviction offense for which we have a sentence recommendation, we exclude prior DUIs. They've been sort of addressed otherwise. And I think, and we have to look at this, I think the same may apply to BUI, but not as many of those cases. And we just have to look at sort of the case law and other issues just to see. But I think it would probably function in the same way, that we would exclude prior BUIs for new sentences for BUI in terms of the prior record score. And then the final thing at the bottom of page 19 are those four groups that I talked about. So you can see the definitions there. Group 1, or G1, is all misdemeanors unless designated as serious crimes. G2 is all felonies of the third degree and unclassified felonies unless designated as serious crimes. And then group 3 includes not only felony 1s and felony 2s, but those three categories of misdemeanor 1s and felony 3s. So Article B, that's the offenses against crimes against persons. So a pretty broad category, chapters 25 through 32. Chapter 61A is the Uniform Firearms Act. And then section 9799.14 is the Megan's Law provision. So again, if there are misdemeanor 1s or felony 3s, they would be treated as F1s or F2s for purposes of that category in the prior record score. And for ease of application, when we get to the list of all of the offenses, we've highlighted in there or created a column where we identify any of those F3s or M1s that fall into those categories. You know that those are ones that would be treated in group 3. And then group 4 are the crimes of violence and the definition of crimes of violence. So I think we all need a break. So maybe we can take about 15 minutes and come back by 3:30 to talk about lapsing.
Let's shoot for being back no later than 3:25.
3:25. Okay, great.
Are always late.
All right, great. Thank you, Judge.
Thank you. All right, so we're back, and we're gonna pick up where we left off. We had just completed going through prior record score, and we're gonna begin the discussion of the lapsing of offenses. And so I'll turn it back over to the executive director to continue.
Great, thanks, Judge. And again, we're returning to the marked up document that was posted, and we're at page 20. And at the top of page 20, we have the lapsing provisions for juvenile adjudications and adult convictions. And we've spent a lot of time talking about this over the last couple of years. Keep in mind that under the current guidelines, we do have a very modest lapsing provision for certain juvenile adjudications. It doesn't apply in many cases. And so one of the issues here, along with trying to reduce the impact of the prior record score, is to try to remove from the prior record score what might be considered stale prior records. And so there are two different approaches here. One is an approach for juvenile adjudications, and the second is for adult convictions. But there are some terms that are used that apply in both cases. So when we talk about decay, it means that just by the passing of time, a prior conviction or adjudication is removed from the prior record score. And a good example of that presently in Pennsylvania is the look back period for DUI convictions. So if it's a 10-year look back period, any DUI conviction prior to that is not considered in the calculation of the grade or the mandatory minimums for DUI. That's an example of decay, that it just, when time passes, once the time has expired, that prior adjudication or conviction does not count in the calculation of the prior record score. The second term that we use is the term gap, and gap takes into account law-abiding behavior. So you set a fixed period of time, but during that period of time, the person has to be law-abiding, no new conviction offenses. And we define that as, I think, excluding summary offenses, but generally misdemeanor or felony convictions during that period would, in effect, restart the clock. And so you need a law-abiding, crime-free period for whatever amount of time is listed. So now looking specifically at juvenile adjudications. Again, these are not transfer cases. These are cases that were disposed of, adjudicated delinquent and disposed of in juvenile court. The person, again, would be 16 years of age or older, so 16 or 17 years old at the time of the offense, and the adjudication of delinquency for those offenses. And it would be limited to, as it is presently, to felony offenses and certain misdemeanor 1 offenses. So under the proposed policy, at age 21, any prior juvenile adjudications for misdemeanor offenses in that lowest category, the G1 category group of offenses, would not be counted in the prior record score. So at age 21. At age 25, we would also remove any of the G2 category or groups. So those would be the other felonies that aren't designated as serious or crimes of violence. So by age 25, just based on decay, time passing, other misdemeanors and other felonies would be removed as juvenile adjudications in the prior record score. And then when we move to the next category, the next two categories, these are gap provisions. So this requires law-abiding behavior. And we're talking about juvenile adjudications that occurred when the person was 16 or 17 years of age. The first is a 10-year look-back period, crime-free behavior since the last adjudication or conviction, to remove misdemeanor and felonies other than those designated as crimes of violence. So this would be felony 1s, felony 2s, and any of the felony 3s or M1s that are in those 3 special categories we talked about. And the final category would be a 15-year crime-free period since the last adjudication or conviction to remove crimes of violence. from consideration in the prior record score. So at age, if you assume, 18 years of age plus 15, so 28, 33 years of age, crime-free behavior since 18 would allow for the removal of a juvenile adjudication for a crime of violence from the prior records. If there was any criminal conviction during that period of time, the gap period would effectively restart, and you'd need another clean 15-year period, or you'd need a clean 15-year period. So that's the general policy based on what we previously proposed, and then comments from the public hearings. Yep, please.
Just quick clarification. So an example would be, let's say a juvenile is 17 and they commit a simple assault or even an aggravated assault in which they're ultimately adjudicated delinquent for.
Mm-hmm.
So 15 years crime free, then that would no longer count. Is that
Right.
correct?
15 years after the last conviction or adjudication. So whatever the last adjudication or conviction date was, 15 years from that would go away. Now for the misdemeanor offense, when we're talking 15 years and we're talking crime free, it's for any offense because it captures crimes of violence. And so anything lesser than that. But for at age 21, the other misdemeanors would go away. And at age 25, the other felonies would go away, whether there was, law-abiding behavior or not.
And where does simple assault fall in that?
Well, simple assault would depend on the grade. So you have an M3, M2, M1, but it's based on the, on the age of the victim, or it's based on the, I guess the age of the victim is the key thing versus the mutual fight for an M3, right? So most simple assaults would be the M2 simple assault. And the thing is, M2s aren't captured in that special category. So that would be treated as an other misdemeanor. If it was an M1 simple assault, then that would be the crime against person category, and that would be treated like an F1. It would be in the third category.
And certainly understanding that at the time of sentencing, a judge can take anything into consideration.
Absolutely.
Do you have, and I certainly assume you do, and again, I'm sure we covered this, but is there data to support that after 15 years being crime-free, an individual is far, far, far less likely to commit additional crimes?
Yeah, I think most of the research out there actually uses 10 years as sort of that look back period. And most of the recidivism studies use 5 years or 3 years. So, there is a reduction in offending over time. The thing about 15 years is not only do you have sort of the general reduction in recidivism just based on time, but you have the aging provision too. One of the I think concerns about youthful offenders is there's still a pretty high rate of offending in the early 20s, right? So that's why you get them into their 30s with the 15-year for the more serious offenses. Mm-hmm. But there's also the sort of the disability that comes about if your criminal record is being influenced by juvenile adjudications 10 years ago or less serious offenses. So this is trying to achieve a balance, trying to say for less serious offenses, we'll use the decay approach. For more serious offenses, we'll use a gap. And then for less serious offenses, we'll just base it on aging, and more serious offenses, we'll base it on, on crime-free period.
And I think this is a really important topic because, we have a lot of young people around that age, 19, 20, 21, 22, that are committing very serious crimes of violence.
Right.
And we also at the same time have a push, I think nationwide, to decrease the amount of young people that are treated as adults after committing crimes.
Right.
And so we kind of have this dichotomy
Mm-hmm.
that I think doesn't always sort of support each other, if that
Right.
makes sense. And because I think about these individuals, especially during that age group that go in and out of prison pretty regularly.
Right.
And one of the questions I have is, so if someone's incarcerated for half of that 15 years,
Mm-hmm.
does the time when they're incarcerated count towards the lapsing provision?
So with a decay provision, incarceration doesn't matter because new offending doesn't matter. It's just a period of time. So 21 and 25 would be like the anchors for that. But for the gap provisions, what we built in on the adult side is that we started with the paroling of the person. So released to the community. So if someone was placed on probation, they're directly released to the community. The clock would start ticking then for law-abiding behavior. But if someone was incarcerated, it would be released from incarceration. So the minimum term or whenever the person was paroled would be the starting point for the clock ticking because they'd be in the community, potentially at risk of offending. And so that's when we start the clock. So we would not start it while they're incarcerated. And some had advocated for that, but this would draw the line at release to the community.
So if you go prior to that 15 years,
Mhm.
how would the 8th edition guidelines impact prior record score?
Well, if it's prior to the 15 years for either a crime of violence or that other next tier, felony 1, felony 2, or special felony 3s, M3, it would have no impact because
Okay.
prior to 15 years, they would count in the prior records.
Okay. I appreciate that.
Sure. So moving to, oh, yes, Rob.
Yeah. Just 2 quick questions. One, for specifically for the gap time period, do technical violations reset that time window, or would it depend on
They do
the
not.
kind of violation?
It would require a new conviction offense and something greater than a summary offense. So a
Right.
summary offense would not count, but a misdemeanor or felony would. And it
Okay,
would require a conviction, not just an arrest.
great. And then the other one, if you're able to summarize, and if not, like just from a high level, how does this lapsing policy stack up to the previous policy that we had?
To the it's certainly more generous because the previous policy was sort of a one-time provision at 28 years of age. If you were crime free from 18 to 28, there was the provision of elapsing. It didn't apply to crimes of violence, but it applied to other offenses. But if you missed that window, you missed out. And I think from the analysis we did, it rarely applied. Yeah. Okay, you bet. So moving to the adult convictions, and this is an entirely new provision. So we've heard over the years public comments about, and from judges, from prosecutors and defense attorneys, about having some provision that dealt with stale records. So that was the real prominent issue. But as we were looking at prior record score more generally, there was, I think, support nationally, and I think support in some of the public hearings we have about looking for opportunities to try to remove prior convictions after a reasonable amount of time. And that's what's sort of the judgment call here. So this is consistent with trying to put more focus on the current conviction offense and less on the prior record score. And it also takes into account some of what the DA raised in terms of just what's the research say about recidivism rates and when does recidivism occur? And, the highest risk time is immediately following release to the community. And then it, trails off. But there's a pretty substantial recidivism rate during 3 years or even up to 5 years. But you get past 5 years to 10, and then you have these very small increases. And they're maybe situational, but they're not these profound increases you see in the earlier years. And then what really impacts that is the age of the person too. Young offenders just are higher offending. It's just the nature of it. So we tried to take those issues into account in coming up with a new adult conviction lapsing policy. You'll see that there's a little bit more focus on gap than decay. So the first category, which aligns to some degree with clean slate and some of the other provisions that have been out there about trying to reduce the impact of prior convictions. If you look at the first category, it's completion of 15 years since the conviction date of the offense. You remove prior convictions for misdemeanor offenses. So that's that lowest category, the other misdemeanors, unless designated a serious crime. So that lowest category of misdemeanors would be after 15 years from the conviction date would be removed. But when we move up to the next category, which is the other felonies or that group of felony 1, felony 2, and special F3s and M1s, that's a 15-year period, but it requires law-abiding behavior. And as I said, that begins, the clock begins when the person is sentenced or released to the street, to the community. So at the time of sentencing to probation, that's when the 15 years would start, or release on parole, that would be when the 15 years start. And it would require a crime-free period, or else the clock restarts. So that is the second category. And then the third category for crimes of violence, same kind of mechanism for release to the street and crime-free behavior, but it moves up to a 25-year period. And I think actually this third category is what I think is we would hear about these kind of things where someone was arrested in their 40s or 50s for DUI or for some other kind of offense, and there was this very old record, and the person had been leading a law-abiding life for a long period of time, but was hit by this 4-point burglary from when they were 20 or something like that. And that's the kind of instance that we would often hear about, that kind of case. And clearly courts can depart. Courts can exercise discretion and mitigate or depart to accommodate that. But what the guidelines do try to do is provide a common starting point. So if there's common features or factors that we can sort of objectify and build into the starting point, that promotes fairness across the board. And so that's why when we're looking at this, we're trying to figure out what's the right circumstance, what's the right definition that captures a group of people that you'd want this to be the starting point, not the end point. It's individual sentencing, but the starting point for consistent consideration of this factor. So these are based on what we initially presented and put in a proposal that we published at the start of the year, and then the comments we received during public hearings and all of the work since 2014. These are the two, I think this is where we've ended up in terms of trying to develop a lapsing policy. And so happy to answer more questions. And again, I think the direction we're moving is to try to figure out what the commission can, reach consensus on for purposes of publishing and getting further public comment. Because, this might not be the end policy, but it's, I think, at least from a staff point of view, the best effort of bringing together all the things we heard and trying to put it into a policy that people could sort of respond to. And so this is what we have, but happy to answer questions or, discuss further modifications. All right. Well, with that, done with lapsing, we'll move on then to just some of the other things. And I think, and I know I'm going to throw us off here a little bit, Ryan, but I'm going to see if we can do this. We have a table that is an illustration of the prior record score, how it works. And I think the table is in effect what we have in section D on page 20 of the process for the prior record score. But I think the table might help if we can display that. Oh yeah, it would be table E. for prior records. All right, thank you. So, yeah, that's great. Maybe bigger. There, perfect. Okay, thank you. So we talked about the 4 categories of offenses, G1 being the lowest of other misdemeanors, G2, other felonies, G3, serious crimes, so F1s, F2s, and those special M1s and F3s, and then G4 being crimes of violence. So if you think about automating this, putting this into an application, the first thing is you have no priors, you get a 0 prior record score. And that's the only individuals that get into the 0 prior record score. So 0. Now that would take into account someone who had lapsed offenses. 20 years later, they had an offense that did count at one time and then it lapsed. They would be in the 0 prior record score category, but only through lapsing would that happen. Otherwise, these are pure non-convictions for prior record score 0. When we get to prior record score 1, there are 2 circumstances where someone could end up with a prior record score 1. They have 1 prior other misdemeanor, or they have 2 prior other misdemeanors. And this is all prior offenses. So we're not looking back at an incident and saying, is this the most serious of the incident? Was this consecutive to something else? We're just looking at all prior convictions and adjudications, saying, is the most serious offense one of those other misdemeanors, and are there 2 of them? And if that's the case, you get a prior record score 1. And if there's 1 of them, you get a prior record score 1. And those are the only 2 types of circumstances in a prior record score 1. So then we move to a prior record score 2, and it would be 3 or more of those other misdemeanors, or it would be 1 or 2 of the other felonies, excluding F1s, F2s, excluding the special F3s, M1s, and excluding crimes of violence. So these are the other felonies. Drug felonies would be included there. And that would be the most serious offense, and there would be either 1 or 2 of those priors in the person's entire criminal history. When we move to the, and then for prior record score 2, you'll see that it's not only the multiple, like 3 or more prior other misdemeanors or the 1 or 2 prior felonies, but it's also a single serious crime. So felony 1, felony 2, or those special F3s and M1s. So that's the prior record score 2 category. Prior record score 3, you can see we start with multiple, more than 3 or more of the other felonies. We include the F1, F2s and others, or 2 or 3 or more of those, and we include 1 single crime of violence. And when you look at prior record score 3, there's aspects of that that sort of look like our current RFEL or our current 5. So it's like in that bandwidth. And for some of you that have been at this table for a long time, you'll remember that we had in our initial proposal prior record score 0, 1, 2, and then effectively prior record score 4. And we did not have a prior record score 3. And 4 was a little bit broader, I guess. And so one of the things we heard in feedback was we should have something that sort of fills that gap for like serious or repeat offenders that aren't crimes of violence, but or repeat crimes of violence, but have a higher recommendation. So that's where prior record score 3 came from. And then the final category, prior record score 4, is, as I said, an expanded revoc. And what that means is that you have 2 or more prior crimes of violence, and it applies regardless of the current conviction offense. And distinguishing it from our current guidelines, under our current guidelines, you would look back at each judicial proceeding or each criminal incident, and you'd identify the most serious offense and that offense would count, and then anything imposed consecutively would count. This looks at just all offenses and says, were there 2 or more crimes of violence? And if so, you're in revoc, and that applies whether your current offense is an OGS 5 or an OGS 20. So that's the rundown of how the prior record score would work and how we would effectively automate it as well. So I'll take a break in case there's questions on that, and then we'll move back to the document to get into the sentence. All right, back to the document. So we're on page 20 of the marked document, and we just addressed D, which dealt with the procedures for determining the prior record score, and the details are listed there if you need it. So moving to the miscellaneous provisions, this is really just capturing stuff that we had in the prior guidelines, just sort of the rules of the road for prior record score. So nothing new there through page 21, and we'll turn to page 22, where we get into the sentence recommendations. And as I mentioned earlier, we've always had sentence recommendations about the current conviction offense, the OGS prior record score, and any enhancements. This now includes a provision about general guideline sentence recommendations that address aggregation of multiple sentences. Now, one provision we had in the last or in the current guidelines, Amendment 6, is that we build in language about the aggregate period of probation, right? Because we build in recommendations, offense-specific recommendations about the use of probation. And it was generally either a year of probation or 2 years of probation. And then we build in a recommendation about the aggregate period of probation. And under those guidelines, we said, if no restrictive conditions are imposed, the maximum period that we'd recommend is 5 years. And if restrictive conditions like house arrest and things like that, inpatient treatment are imposed, then the aggregate max is 10 years. And what we heard back then and what we continued to hear during public hearings is, for purposes of probation, less is generally more. That having very, very long periods of probation are generally not particularly useful and can be counterproductive. Now, there's always going to be exceptions. And I think the biggest exception we often hear is things like sex offender cases, where you just want some community supervision and the ability to intervene if necessary. But for many cases, short periods of probation for the purpose of community supervision or treatment, other things like that, seems to have the best outcomes. And so the recommendation here is to sort of think in terms of 5 years as far as the maximum period of probation supervision. The reason we use 5 years as well is, as many of you know, the General Assembly there's been legislation pending in the General Assembly for several sessions now that really does look at creating hard caps on the use of probation, generally at 3 or 5 years. And as the commission has done in the past, as alternatives to mandatories and other things like that, advisory guidelines are sometimes a way to put a general policy in place for consideration without there being sort of the heavy hand of mandatory caps or mandatory minimums. So there may be some benefit to thinking about what seems like a typical and appropriate target for the use of probation, knowing that courts have the latitude, have the discretion to go outside of it. So moving on, unless there's comments, there might be a comment.
Just quick point, Mark, and I've brought this up numerous times, and I'm trying to creatively come up with some sort of solution. But one of the crimes that really, well, there's a lot of crimes that bother me, but there's one that happens.
That's your job description.
They bother me. Yes. One of them is economic crime.
Mhm.
And I have repeatedly for years seen the following scenario. Someone steals like $400,000, okay, from whoever.
Yeah.
Okay. And because of the nature of the guidelines, and other factors that may present itself, even if they plead open, okay, they're getting a minimal jail sentence.
Mhm.
They're going to get, they have to pay that restitution back. It would technically take them like 500 years.
Mhm.
And then down the road, they might petition the court to have that restitution number changed based on the circumstances. And I just really feel like we're missing something here in that, there are people who commit, 4 or 5 retail thefts that get stiffer sentences. And I don't want to go into the realm of legislation.
Yeah.
I completely understand that. I'm just saying, when I think of probation, one of my worries is, if there's anything like a cap, is that it will put us it'll further handicap our ability to do what we can to get as much restitution as possible for individuals that have had a lot of money stolen.
Yeah.
I mean, I just don't, these white collar cases seem to, it just seems like it's easier for those defendants to kind of skate through the system.
Sure. Yeah, I agree with you, and I know you've raised that a couple of times, and I guess 2 or 3 comments, and look, as I said before, I'm really open to any specific, recommendations you have. One of the limitations, of course, is the statutory max based on the conviction, and sometimes you can deal with that by the way you charge in terms of multiple counts, where you have more flexibility, but sometimes if it's all thrown together, then there are some limits on that. And then a second thing is, like, what are we trying to, or what are you trying to get out of this? It sort of gets to purpose of sentencing and other things like that, but is it about the restitution? Is it about sort of a retribution in terms of accountability that may be involving punishment, like imprisonment? What exactly, like, what do we build into the guidelines to, like, address what you see as the appropriate sanction or punishment for that? And then the third thing that we always ask about with the guidelines is, what's typical? And so, when there are cases like that, if they are exceptions to the rule, then we would expect the court to individualize the sentence, aggravate, depart above, be creative, because it's a unique circumstance. If it is typical and there's something we should do because it's what you're seeing every day, then it makes sense that we come up with something that's consistent and proportional and uniform and all that kind of stuff. So those are just sort of the things we try to take into account, but I'm really happy to look at that. I think the last time we talked about this, one of the things I suggested was, the way we sometimes deal with, like, those kind of fact patterns or those kind of specific circumstances related to an offense is through an enhancement, where we say, well, here's this theft, but, here's this circumstance that's present, and therefore, here's our recommendation or our adjustment or whatever else. But we still have to work within the footprint of the statute. And so sometimes that's limiting in terms of what's the statutory max or what's the fine. Now, I think one of the things that you pointed out was, clearly for restitution has to be ordered in full. And then the question is, how do you make progress on collecting that? And there's 2, modes for collecting restitution: a direct order of restitution, and restitution as a condition of probation. So we certainly want to encourage maybe both of those, but at least the direct order, so that they're not time limited on paying the restitution, right? But then there's also, like, the fine section of the guidelines, where we can also address other economic sanctions. So, we focus on fines and community service, And we generally have said there's limits on fines unless you take into account that you can do at least double what the loss was, right? So there's some flexibility there, and using community service in lieu of fines or something like that is something, but we've never gone into looking at like restitution in cases like you're talking about. So maybe there's something we can do there because we have the authority to do guidelines for economic sanctions. And if we look at theft as a category or fraud or something like that as sort of white collar things where there's big losses, I'm not sure what the answer is, but I think we have some tools that we could use if there were a way of capturing that.
And I don't know, I just wanted to pop in, I don't know where this will all fit in, but there's, like you said, there's retribution versus do you want to collect the money? And I do costs and fines in our county, so I live this a lot. Whether it's a violation for their, probation that they're not paying, or whether it's a contempt on the court order, if you're really about collecting money in Cambria County, there's a $40 per month supervisory fee. So that's $480 a year. So if you're really trying to get money for the victim, I have people, you still have to establish what they're making. And I have people who, when they do come in and they're honest, but they're working at a fast food place and they have 2 kids, so how much can I get from them? And if I can only get a $50 per month payment and 40 of that's going to a supervisory fee. So if money collection is the issue, lengthening the period of supervision, I think isn't. And then if retribution because of what they did is, and I've used to have some of those cases, they're aggravating, but in terms of real life for collection of money, that actually impedes your ability to get money if you extend it.
So, Judge?
My question's a little different, so I didn't know if you
All
wanted
right.
to respond. And I really just don't want to leave my page to find out what's in 303.1D. But, my concern is, and I know I speak for colleagues, in terms of the length of probation, is that we're realists and we know that for outpatient drug treatment, and that's where I'm a little concerned with medically assisted, a lot of times they're not. We'll have someone on our probation that gets to 2 to 3 years and then they relapse.
Yeah.
And it is just much easier in our jurisdiction to get someone into a program if it's court mandated.
Mm-hmm.
Versus then if they're done with probation. And I have actually had individuals ask me to continue their probation.
Yeah.
And we have those issues with payments and fines too, but we'd rather them get the drug treatment. So sometimes we want, and I'm trying to figure out, is that a 5-year or is it 10-year? Usually we don't go past 5
Yeah.
or 6 no matter what, but I'm telling you, 3 is sort of like the rock bottom, what we see
Right.
for people to start licking these serious drug problems.
Sure.
It's not a year or 2. And it's
Yeah.
most of the time it's not 3.
No,
It's going to be through 1.5 to 2 years, good for a year. And then bam, something's going to happen and they're going to go back.
Right. And one of the things that we have in the current guidelines that we built in last time that we retain here and try to build up a little bit is, recognizing the whole space of like treatment, mental illness, drug use, all of those kind of things as appropriate individualized factors that are, justified for aggravation or for departure when the duration or intensity of supervision warrants it. Because, we were big in the 90s on trying to provide this trade-off to incarceration for clinically prescribed treatment. DAs at the time, everyone, on board and really promoting that, where we recognized, level of care, length of treatment has more to do with a clinical determination, behavioral health issues than with like retribution. So that's why I am concerned about hard caps on probation and trying to find a way to promote best practices, but provide the exception so that exactly as you're talking, as both of you have talked about, that there's like clear sailing to be able to do the right thing, to provide supervision and treatment that's needed. And so skipping ahead a little bit, if you look at the sentencing level stuff on page 23, the highlighted section about treatment alternatives, we tried to like expand that discussion, take it out of just aggravated and mitigated, and put it as a central issue about sentencing recommendations. Like this, if that's the purpose, if it's a rehabilitative purpose, then there's like different things you should be considering or be able to consider in both in terms of intensity and the type of treatment and the duration of treatment. So, maybe that doesn't do it all, but we tried to like put it in there so it has more prominence and that it's not as an exception to the rule, it's baked in, sort of like we did with the trade-off with treatment in lieu of incarceration with county IP stuff back in the 90s. So I'd encourage you to sort of look at that, where we try to pull in a bunch of things, and we've included a reference to medically assisted treatment and behavioral therapies when clinically appropriate. We also put in, information about problem-solving courts and other kind of court-supervised individualized treatment programs, and we also reference like the programs at DOC for drug treatment and the use of restrictive DUI conditions and probation with restrictive conditions. So I'm not sure if that's enough, but it's some effort to try to say these aren't caps, but if you're not doing it for a treatment purpose, less is probably. So let me keep moving on because we have some stuff to cover yet. Some of this we can roll over to tomorrow, but I'd like to at least try to get through most of this. So the next several pages from page 23 through 25 or 26, okay, maybe 28, it gets to the sentencing levels. And if you think about the current guidelines, very colorful matrix, we have 5 sentencing levels. And we sort of think about, generally speaking, community supervision, county jail, state prison, and really serious state prison. But we have, it really overlaps. And that was one of the criticisms of JRI 2, that we provide, it's sort of all of God's children can fall into these recommendations. And what they suggested was these are advisory guidelines, be more focused, give a recommendation about a disposition and a tighter duration, and allow the court to determine whether that's appropriate or not, advisory guidelines. So what we've done in redeveloping the guidelines is, in addition to adding more OGSs, we provide pretty discrete levels, where levels are focused on the disposition available. So level 1, it's basic, level A rather, it's basically community supervision without probation. And then level B is probation. Level C is county jail. And then we get to like a variety of state prison, because there's a whole lot of things that go into state prison and duration of sentence up to murder 1 and murder 2. So if you look at the matrix and you see the different color bands, they associate with different dispositions. And these levels explain those dispositions. So I'm not going to go through all of these, but what I have highlighted is sort of the purpose or the target for each of the levels, so that you have a chance to look at that. People tuning in can look at that, see if it makes sense. And that's certainly something we'd want to hear about in public hearings, but it basically better defines discretely each of the sentencing levels. And we target offenders towards that level. And then moving on, when we get past the sentencing levels, which ends at page 27, we then pick up aggravating and mitigating factors or circumstances. We've always had this in the guidelines as far as discussion of aggravating and mitigating ranges and use of reasons. But what is quite different this time around is that we are including a list of reasons for the sentence. And this we discussed over the course of public hearings and during commission meetings. This is a non-exclusive list, so there can be others listed. We don't separate them by aggravating versus mitigating, because we found over time that some check both boxes. But we did break it down according to what the statute recommends, which is there may be reasons that relate to the nature or circumstances of the offense, and there may be reasons that relate to the history and character of the defendant. And we tried to come up with those two categories, and then we used reasons that were provided during public hearings, reasons that were common in reasons reported to the commission for departure sentences, and reasons that were addressed in previous editions of the guidelines, especially the early edition of the guidelines where they did have some of the reasons listed. And then we included as an E2 on page 29, the information about sort of those clinical determinations, like assessments of risk and other kind of things that look at the intensity or the use of restrictive conditions. So we wanted to build those factors in as well. So we had this list or something close to it before the commission. I know there's some things listed that there were some concerns about, and some were added to address other issues that were raised. So I just sort of point that out. We can always return to it, but I did want to point out that we did put that list in into the guidelines, and we have not previously had a list of aggravating and mitigating factors.
If there are reasons on there that we don't like or
Mhm.
don't agree with and articulate, are these things we'll discuss tomorrow? Or do
We
you wanna
can, or
discuss
we can
them now?
discuss right now. It's your call. I think, you know, if we go with like this ideal that I have in mind, that we'd get to a point where we'd actually approve something to publish, then it'd be preferable if there's things that you don't want on the list to just strike them out now or
I-
add them.
Then I feel, and this has been, we've discussed this before, under 1I E, victim induced or facilitated incident. I think that should not be there. And I think C, you can take the kinds of cases you're talking about. So for example, let's say it's in a bar and it's two individuals who have been drinking. And I think that this creates a risk for misuse to the detriment of victims.
Okay.
And I think you could address the behaviors that you're trying to encompass under C using the argument that individual acted under strong provocation, and they can make that fact specific. So I feel strongly about that.
Okay.
And if I may,
Yes, please, Joe.
and I can't discuss it because it's an ongoing case, I would have agreed with you until recently. But I now disagree with you. And in essence, I've already said that on the record in a particular case. And that's all I can say. So I think very limited circumstances, and it was different than acting on, I think it was a different circumstance than acting under a strong provocation.
So is there, so if we're talking about E, about either removing it or not removing it, is there a different way of phrasing that would be more sensitive to the issues while still retaining something like that? Okay.
Start by taking out the word victim. I don't know how you rephrase it, but that's, I mean, I had the same red flags going up when I read that as
Okay.
you're victim blaming here.
Yes.
So-
And I guess these are non-exhaustive.
Right. Right.
So if you have an outlying case
Mhm.
where there is a particular reason, because I know we can find, and it sounds like that's what you had,
Mhm.
but it just makes me nervous to put it on a list, a non-exhaustive list, because someone can articulate another reason.
Sure.
With the knowledge of a theme that we've accepted throughout this entire process,
Mhm.
which is that these are guidelines,
Right.
that individual judges under the circumstances clearly can articulate really whatever reason they want at
Sure.
the time of sentencing. This is a non-exhaustive list. With all that being said, you know, my position is that I think that we should absolutely not have victim induced or facilitated the incident as a stated option.
Okay.
But we know that under the right circumstances, a judge certainly has discretion to take that into consideration at the time.
Because I think there's a, I think.
Why don't we just,
Yeah.
why don't you just say circumstances that induced or facilitated incident? That takes out the victim word.
Okay.
Attorney Marsico is speaking for those who want identification.
So circumstances that induced or facilitated incident.
Yes.
All right. Well, one of the things is we do have a dinner meeting tonight that was noticed. So we can have further discussion of details like this and other things, but just for the sake of time, trying to move along unless, did you have it? Yes. Ro-
Yeah, it's one quick about a separate one. So for
Mhm.
purity of controlled substance, is that for aggravating or mitigating?
That's the thing. These are actually, these can work in either
Neutral.
direction
Okay.
because we've seen that reported to us both
Right.
ways. So
Okay.
that's why we came up with sort of things related to offenses, things related to the individual.
Right. So my question on that was because so earlier in the guidelines there was also the provision about, you know, depending on the substances and the
Mhm.
compound, if
Right.
there's like whatever is the highest amount in terms of offense score is what's used to grade the compound.
Right.
So say for example, you know, low level dealer has some stuff, doesn't realize it's cut with something else that's
Right.
like stronger. Is there a situation where someone might use the purity as a mitigating offense because they're like, oh, he didn't know it had whatever, but then whatever that substance is that was cut has a higher.
Yeah, I think
Great.
it could be used in either direction. This was, I think this was put in here because of exactly what you said. Since we look at a substance or compound, you could have, pure cocaine. That was one of the things about crack cocaine versus powder cocaine. There wasn't, a lot of cutting agent there, and so the purity was an important factor that we heard about at sentencing. But I guess it could work just the opposite way, where you thought it was just marijuana and it was laced with fentanyl, and so I think it can work in both ways. And again, that's why we're trying to make sure they're not aggravated or mitigated, but more about the offense versus the individual.
Okay.
Okay, let me move on so that we can move on. And the last section then is on page 30, and this is the new edition, and this deals with thinking more holistically about the sentence recommendation. So we've done recommendations on individual counts. Now at sentencing, in a sentencing proceeding, judicial proceeding as we call it, there may be multiple offenses. And so these are several recommendations that would not be used for conformity, but just as general guidance for consideration. So the first is, and we talked about this before, some type of statement about concurrent consecutive. And the idea was that when there are multiple counts, the general consideration is that the guidelines encourage consideration of imposing concurrent sentences for lesser conviction offenses. And then we list a number of exceptions, including sentences for crimes of violence, sentences where the statute requires consecutive sentencing, and we listed a number of those, and then proceedings in which there are multiple crime victims. So those were some of the explicit exceptions. But again, this is just a general starting point. This is not something that we will deal with in terms of conformity, because first, it would be very difficult to sort of figure out conformity around this. But absent, right now we say nothing at all. So anything counts. And so we're just trying to find something that provides a starting point for consideration of concurrent consecutive. I'll hit these other ones and then any kind of comments.
Hey, Mark, before you
Yes, please.
jump
Judge.
on, so when you're talking about judicial proceeding and multiple, is this, like this morning I had a case that was drug dealing one day, cockfighting 6 months later, assaults in between. So different dockets, different incidents that all caught
Right.
up eventually
Yeah.
to come in today. Is there anything in that regard, or is it just like by incident?
Well, at least in the way we have this framed is around lesser offenses, lesser conviction offenses, which makes it sound like an incident. But we can define this however you want. It's just we have nothing right now, so we're looking for anything as a starting point. I think, look, I think at the very least, it would be helpful to say something about an incident because we've talked before that there's different charging practices across the Commonwealth, and you can end up with substantially the same cases that look very different in terms of the number of conviction offenses. So focusing on concurrent lesser offenses is a good starting point, I think. Whether you extend to different incidences over time and all those other things, whatever makes sense is fine with me. I think we should do something though. So I think if it would help to limit this to incident, that would be a good start. But, we look at cases where, there's offenses over, a spree or something like that are clearly different incidences, but they're all a common theme, a common whatever. And, maybe there should be consideration there, but I'll take whatever I can get, I think. So DA Sunday.
So with the understanding that if there's multiple victims
Mm-hmm.
or something of that nature, then that would be excluded.
Right.
I know that, isn't the phraseology of within the same criminal episode?
Episode was what we used to have in the guidelines a long time ago.
Yeah.
Boy, I'm aging myself. But we had criminal episode. We've had a lot of different takes at this. But I think incident is one thing that we've been using fairly commonly about when the offense occurred, like what was related together, what was charged together. And we distinguish it that way. With state police and others, they have incident reports, so that gets to sort of like a grouping. So that's why incident seems to be a phrase that we could use. But the other phrase we use is the sentencing proceeding, what we call the judicial proceeding. And that I could get, that might seem too broad, except that you do have the exception for multiple victims and multiple crimes of violence. But maybe that's too far. They're separate events, so treat them separately.
And it's very common that people will continue, defense attorneys will continue their cases
Right.
because they're new charges.
That's
So
right.
what is it? I always say you don't get the discount double check or whatever.
Right. Right.
I mean, sometimes it depends on the person if it's a treatment related issue, but I think we're all kind of on the same page,
Okay.
except keeping it by incident. 'Cause
By incident. Okay. Thank you.
Just
Sure.
policy wise, I just wouldn't want to handicap the
Right.
court's ability to take into consideration the circumstances and do consecutive sentences under the right circumstances.
Right.
that's all.
Absolutely. And look, let's be incremental about this. We have nothing, so having something is really wonderful. So, okay. So there's other issues here. One is once you have whatever the aggregated sentence is based on concurrent, consecutive, all of that, we put in a notation about here's the time where you can think about, is the person eligible and appropriate for state drug treatment program or for the state motivational boot camp, because you're talking about now an aggregate sentence of confinement in a state facility. Now you get a chance to think about those kind of programs. So I think it makes sense to sort of think about this second tier of consideration. And then the final thing gets to that consecutive probation period we talked about, and whether we extend that or add in some more language to Judge McDermott's point about, especially about treatment and things like that. I mean, I want to make sure we're considerate of those kind of factors, but the other concern is if there's nothing out there, that's an opportunity for caps and stuff like that, which I think are counterproductive. So, okay. So let me move to a couple of final issues, and then I'll talk about a couple example cases, and gosh, it'll be time for dinner. So, so the document that I think we could put up, and I don't even think I mentioned it, there is the matrix. And in your packet, I think there were two of them. One, we just sort of cut and pasted into the document to show like the Pennsylvania Bulletin where we would have it. And the other is actually a clean copy of the matrix that you might be able to read. So Ryan has placed one of those up there. And so we've been talking about this a lot and the OGS assignments and so forth. So I thought this would be a helpful starting point, and maybe you could blow that up. Okay. Yeah, what? Okay, that's apparently not my job to work on that, but. So while Ryan's working on that, I'll just remind you of the, sort of the color theme we have going here, that for each color band, it's a different level. And we start at the bottom with white at level A, and those are the non-probation recommendations. So basically for what we call restorative sanctions, and it would be, there we go, and it would be, fines, community service, guilt without further penalty, those types of things. And if you think about and you look at what we have recommended for OGS assignments at level A, primarily around OGS 2, these are offenses in certain counties that are handled by MDJs because they're basically misdemeanor 3s or unclassified misdemeanors. And during public hearings, and especially out of the hearings in Philadelphia and with defenders, we heard a real concern about not having like enough OGS assignments at OGS 2. And so we at our last meeting with all of you, we identified a lot of lower level thefts and other types of property offenses that we added to OGS 2 to provide those additional values. And just so that you know, and for the public, at level A, most of our assignments are at OGS 2, because then that provides a mechanism for aggravation or mitigation within the level A. So, so most of the targets there, we have very few assignments that are OGS 1 or OGS 3. They're almost all OGS 2. So that's the first level. The next level up then is probation. And probation, we go up to a typical recommendation for probation up to 24 months. And that's on a given count. Keep in mind that most of the assignments there at level B are misdemeanors. So this is, taking into account that in many cases it's capped at 2 years, although there might be some misdemeanor ones there that would have more value. And the starting point is probation without restrictive conditions and recommendations for effectively for hours of community service that could be converted to fines based on just determining the hourly rate or minimum wage or other kind of values that could be used if a fine was the preferred option. As you move across in the prior record score, we then build in to address intensity, the use of short periods of restrictive conditions, and we increase the number of hours or the fine that goes with that. Moving up to level 3, which is darker green. This is the county jail section. We expanded this in 2 ways. We added a couple of values, and we did this during the last meeting, I believe, but we added a couple of OGS values and we expanded the range by a month or 2. I think Judge Marsico and others had raised the concern about how tight the county jail recommendations were. So we think we built that in appropriately. Again, at level 3, there's always the trade-off available. So while these are recommendations for county jail, in every one of these cases, there can be a trade-off with the use of restrictive conditions of probation. And we build in the policy we've had since the 90s in terms of clinical assessments of drug dependency to promote the use of drug and alcohol treatment. next level. So the light blue is sort of this is sort of a hybrid area. It's the lower level of state prison if your county is not authorized to use your county jail for maximum sentences of 2 years or greater. And that's most county jails. So the presumption is that they're served in a county, in a state prison. But there are counties that have the authority to use, because they have capacity of using their county jails for sentences up to a max of 5 years. And so that's sort of this hybrid category. In the old guidelines, I think this was like level 3, level 4 of the guidelines, where we had sort of a hybrid. And then when you get to level E, this is strictly place of confinement is DOC. And this is DOC across the board. And if you see, here's a good example where you see there's many more OGS values, OGS categories, because what we tried to do is have a more consistent step up, step down that was available for purposes of enhancements and other things like that. So it's a much more consistent and uniform increase. And it also allows us to then target the OGS assignments. So we can look at the median sentence, and instead of saying, oh, this fits somewhere between 12 and 24 months, we can say, no, this fits, the 12 to 18 month range as the starting point. And then the court can consider aggravated and mitigated. Moving up. And these are just continuations of other aspects of state confinement. So as we get past the middle blue, we get to the darker blue. And at F, you'll see that this is a category that we have reserved, but it's not exclusive, but it's reserved for cases or for offenses where the statutory max is greater than 20 years. So murder 3 would fall in here. Inchoate murder resulting in serious bodily injury. So both of those have 40-year maxes. Other offenses that have life maxes, or rape of a child under 13 years of age, things like that would fall into this category. But there may be some of those offenses that fall down in the category below that. It's just you only get into F if you have a statutory max of greater than 20 years. And so this is the section we'll be looking at when we're talking about murder 3, because if you look down at 27, 20, it's hard to read those things, but oh, okay, 23, maybe 24. 24 starts at 72 months. So 72 months, that is the bottom of the current range for murder 3. And the top of the current range for murder 3 is 240 months. So from 24 up through 30 are potential assignments for murder 3. And because the murder 3 has a statutory max of greater than 20 years, that the general target would be F of 27 to 30. And I think the assignment we have right now is, I believe, a 28, because it takes into account 27 or 28, because it takes into account the median was 144. And we wanted to make sure we built in a step up if it was a victim under 13 years of age, because we have to do an enhancement. So lots of those kind of things play into it. We'll look at that in a minute when we look at murder 3. But that gives you a sense of the offense gravity score, OGS values, as well as the sentencing levels. And then Ryan, if you could just go up a bit more. We have the final category, which is murder 1, murder 2. That takes into account, of course, the defendants under 18 years of age, and we come up with the 3 categories. So those above 18, those 16 and 17, and those under 16, and murder 1 versus murder 2. And then if you look across the top, that's where we have the prior record score categories. So you can see that 0 is the pure 0, 1, 2, and 3, and then we get over to 4, and you'll see that for prior record score 4, the REVOC category, in all cases, the statutory limit is the upper limit of that. So in every case that you have 2 or more prior crimes of violence, the court can go as high as the statutory limit, the longest minimum term permitted based on the conviction. And if you just page down, Ryan, you'll see that that SL at the top end of REVOC extends down to the other offenses, the other OGS categories. So that's a difference from before where REVOC was limited to just a current crime of violence. This takes into account a serious prior offending behavior and gives the court a lot more latitude until you get down to C, I think, where we have some caps there. So that's the rundown of the matrix. I'm going to save you the time of going through 60 pages of OGS assignments, but I do want to just bring up 2 example offense pages just to sort of show to you. And again, we can engage in any kind of conversation you want. So we'll start with, let's start with that one. And these are documents, at least I think I provided you with both of these documents in advance, but I will just sort of talk briefly about them. This document was, I think, developed early on, and it might have been a list of scenarios provided, I think, by the DA's Association or from a number of DAs where they asked for a comparison under the initial proposal of the current guidelines and the proposed guidelines. And I used those same offenses, same scenarios, and reran them with the new guidelines. And I think what you'll find is there's a pretty consistent matching. Now, remember, the new guidelines have narrower ranges. So it's going to either favor the bottom of the range or the top of the range, and it does a little bit of both of those. But I think generally the new recommendations fit within the footprint of the current guidelines. And so, if as you look at these, if you'd find circumstances where you think, well, instead of a 15, maybe it should be a 14, instead of the top of the range, it should be the bottom of the current range. We can do those kind of adjustments, but part of this is just to show that we're pretty consistent with where we started under the current guidelines. So we're just trying to narrow and focus from where we are. So I'm not going to go through the details of this, except that it's there, and we can certainly discuss it over dinner, or we can, that's a great dinner conversation, or we can, talk about it tomorrow during the meeting. Let me move to a second document that's available there that you can look at, and it deals with deadly weapon enhancement. And this was provided following one of our public hearings. We had 6 public hearings on the proposals we published in, I think, January. And we had some individuals. Anyhow, I tell you. So the document you won't see right now, but that we have in the materials, was a list of offenses for which there was no DWE, DWE, deadly weapon possessed, deadly weapon used, and all of the prior record score categories. So you got sort of a full flavor of certain offenses and weapons. And so we updated that document as well, where it has all of the sentence recommendations under the current guidelines for those scenarios for no DWE, DWE possessed, DWE used. Look at that. Here it is. And then at the bottom, we reran them using the new prior record score categories, new OGS assignments. And again, I think you'll find that generally speaking, there's, we are in the footprint, but this gives you a chance of really looking at the details of prior record score and how it plays out. So again, a lot of stuff to digest, but this was responsive to issues we heard and information we received during public hearings, and we wanted to provide an update of that. So that's available. And now I'm going to close with what I promised earlier, and that is a discussion of Murder 3. And we're going to move to a couple of PowerPoint slides that will move at a pretty quick pace, but just to outline some of the issues we talked about. So keeping in mind that OGS assignments are about the typical range for the typical offender, we're trying to figure out what's typical for murder 3. So first, next slide. So here's a list of, under the current guidelines, OGS 14-0 prior record score. The standard range is 76 to the statutory limit, which is 240, and the mitigated goes down to 60. So 60 to less than 72 is the mitigated range. So anything below 60 is a departure below, and you can't go above the statutory limit. So there's no aggravated or departure above. So the typical sentences that are included right now in 240 max, a 40-year max, murder 3, and that includes murder 3 victim less than 13, murder 3 of unborn causing suicide, but also inchoate murder when there's serious bodily injury, rape, victim under 13, and so forth. So you get some sense of some of those offenses that would be sort of in the same grouping in terms of classification. And then we have some other offenses that have lower statutory limits or maxes. So manslaughter of law enforcement and fentanyl, just as sort of a, to give you some context. Next slide. So when we look through some example offenses of murder 3, we tried to just find instances that might give a sense of the spread of circumstances. And we talked about this before, that at the high end, you see cases that look like murder 3, but there was a murder 1, but were negotiated a murder 3. And you see cases that look like voluntary or even involuntary manslaughter that ended up with convictions for murder 3. So we have a very wide spread, and there's a lot of circumstances listed there. And we could do this with, many, many more cases, but this is what we had at hand just to come up with some examples. Next. Okay. Whoops. Okay. So next one. So this is that distribution I talked about, where we looked at all of the murder sentences, 0 prior record score. In this year, there were 57 cases. And so this is a distribution of the sentences imposed. And you can see that, remember, the range was 72 months to statutory limit. We had down at the bottom at least one case of probation. We had 9 months, 12 months, 20 months, 60 months. Then you get to whatever that is. I need new glasses, but yeah, 72. But as we get up to, you'll see at 120, so the longest minimum period, that was the most typical. That was about 25% of the cases. And you'll see at 120 and I think 108, there are some pretty, substantial numbers there. And about 80%, 89% of cases fell within the standard range of the guidelines, but it's a pretty big target there. So we wanted to look at those cases and get a little more detail. So next slide. Thanks. So this is a breakout of those offenses, and you can see, or those sentences. So you can see, like at the very bottom, that was the most typical sentence, the 240 months, 20-year min, 14 out of the 57 cases, about 25% of the cases. At 180 months, you had about 15% of the cases, 14% of the cases. And at 120 months, so 10 years, you had about 20% of the cases. So the median sentence, as I said, was 144 months. So those really pulled up the average. But if you look, there were a lot of sentences below that, including a sentence at non-confinement. Next case. Next. All 0 prior record score, no deadly weapon enhancement. So 0 prior record score. So here's the cutaway from the matrix that I showed you. Remember I said that from 27 to 30, I'm sorry, from, I'm trying to see, from 24 to 29 is, let me look at my matrix. Yeah, from 27 to 30 is the section F, level F of the guidelines. So that's where the maximum of greater than 20 years is found. And if you look at the cutaway, we start at OGS 24 because that's the lower limit of the current guidelines, 72 months. So the question is, if you took the 24 through 29 as sort of the target zone for trying to come up with an assignment for murder 3, like where would you plug it? Where would you plug in murder 3 based on what you know? If you know that 240 months was the mode, and then 120 and 180 were pretty well represented. The median was 144, but you had a bunch of cases below 144, right? So which of those OGS categories with the recommended sentences would you use? Now, in a lot of cases, our starting point was to look at the median and use that as the starting point for the assignment. And so we'd say, okay, 144 months is going to be what we use for a murder 3 assignment. Well, that would put you, way up there. It would put you at 29. And what we had to keep in mind was we need to have an assignment for murder 3 when the victim's under 13, because we have an enhancement we have to build into the guidelines for that. So you can see some of the assignments that we have there, and at the very top at 29 is where we put the murder 3 victim less than 13. So it's a crime of violence and it includes an enhancement. And so one step below that at 28 is murder 3, which is 114 to 138. So it's still, it's still relatively high compared to our starting point of 72 right now, but it's certainly well below the median that we found for 0 prior record score, no enhancement. And then you can see some of the other offenses we have listed, like the inchoates to murder, are listed as well. So the question is, like, what do you do with this? Like, if you wanted to come up with the typical sentence for murder 3, as far as the assignment, what value would you pick? And is there a way to subcategorize it in any way? And if not, is there a rebuilding of this that we should be looking at? So, you could say, well, those ranges are, they're wide, but they could be wider. So, do you combine, 25 and 26 and 27 and 28 and 29 and 30, so you're doubling that, and it gives you a little bit more latitude. But when you're doing that to accommodate murder 3, then you're also providing pretty wide ranges for, rape of a child and other things like that. So this is where we are right now. And I'm not sure that we reach consensus either with the public or within the commission about what the right assignment would be. But at this point, for purposes of moving things forward, I guess we'd be recommending the OGS 28 as the assignment for murder 3, and one step higher for murder 3 involving victim less than 13, unless you think we should consider some other assignment. Judge?
And a couple of things. For those first degree murders where it's a negotiated plea to a 3rd degree, that's so far off from where you're going to hit. So this was I made this notes earlier, just an idea is, could we, in putting forward the 8th edition, keep murder 3 with a broad range and then create some requirement of reporting the reason, because they're all standard range, so we don't have any reasons on the record for why they went where they went. But if we required on any 3rd degree murder a reason on the record, and we can be and then when we collect data from that, we can start saying what those are, and we could create categories, because right now we're kind of closing our eyes and pointing. We can guess that but for all the other offenses, when we say typical offense, typical offender, we sort of know what that means. But when you say murder 3, it's such a catch-all that I don't think you really can say typical offense, typical offender. And I certainly don't think we have enough data to say this is the kind of field where we're seeing these. This is the kind of field. I think it's very dangerous to pick a number because we're going to swing so high or so low because of the broad net that of types of murder, third-degree murder behaviors
Yeah.
it encompasses. So my thought was, could we leave it like it is, put that requirement in, take 2 or 3 years of data, and then revisit? And then that could be our first amendment to the 8th edition.
Okay. I'm glad you're thinking ahead like that.
Thinking
So,
ahead.
so here's the, yeah, maybe. And so here's something we have to think about, just like, how do you build it in? Because right now we have all of these OGS categories. And now one way of maybe getting around that is we say, sentencing level F applies to murder 3. And it gives the court anything within F to pick from. And that isn't great, but at least it gives you if I could even read those numbers, but I think it gets you down to 96, is it? 90? 90. 90 as the bottom of the range, and it gets you up to the top of the range of, like, I don't know, whatever it is at 29, like 162, 186. Yeah. So it does give you a big range there where you can say, instead of an OGS, we're giving a level. And you have latitude within that. But exactly what you're saying, it's not about the OGS, it's about providing reasons for the sentence. And we try to capture that. And now we have reasons for the sentence as part of the guidelines. So we'd be trying to capture information. And if any of the reasons we have identified for murder 3 are not in that list of reasons for a sentence, maybe we think about adding those so that we have more detail available.
Mark, what are we doing first? On first and second, don't we have guidelines? now
Yeah,
for
they
those?
they are. So if we can go back to the matrix, and
And we-
so that's level H for homicide, and it is
So it's broken out separately.
it is broken out separately because we have those mandatory minimums
As a
for
Miller.
Miller, right?
Right.
Which Judge McDermott knows all about. That's her, that's her document.
And I know
So,
why we ended up there, but I'm
Yeah.
just saying that it is sort of a breakout. It's different.
Yeah.
And I know we want the uniformity
There
of
we
the
go.
guidelines.
So there's H for murder 1 and 2, and it's broken out that way because there's those mandatory minimums
Right.
based on the category. But we can, so if we look at that, we could say for murder 3, instead of, those specific assignments that we can use for other specific offenses, for murder 3, we can say, level F is the thing. And that gives you, it's tighter than what we have right now, but it's much broader. It gives you, much more latitude than any single cell would. And it allows us to collect information about, like, what's going on to try to improve the guidelines in Amendment 1 that occurs sometime far in the future.
And that would be 90 to what?
It would
Let's see.
be 90 to
186.
186.
Which is what's that?
And 240 is what a lot of
Right,
negotiated
so that
first,
takes you to
Yeah.
15
third
and a
are.
half.
So
Yeah, 7.5 to 50.
Yeah, I just,
That would be.
so I have a question.
Yeah.
When the cases that you looked at, were they true no deadly weapon enhancement? Now, you said they weren't applied, but
Right.
did you look at the factual
No,
scenario?
we did not look at that. And that
Because-
gets to the issue, right?
Yes, because we're going to calculate the deadly weapon enhancement in, and I guess I'm questioning how reliable is that data if we don't know whether or not they didn't include the deadly weapon
Right.
enhancement.
So,
Because then everything would start a little higher.
right. And so, well, here's the thing though, if they're not doing it now, would they be doing it differently in the future, right?
Well,
So-
we're making sure by the way we are doing the guidelines.
Well,
that they
that's
pretty
what we're
much
trying to
have
do, but you have a choice right now about whether you build it in or don't build it in. So you can, develop this the way you want. And I appreciate that. So for instance, if the decision is deadly weapon enhancement does not apply to murder 3, then that would be your starting point for deciding what is the assignments here. If you think the assignments are low, then maybe you say, no, deadly weapon enhancement does apply to murder 3 as it does right now. And we'll be building it into the application to try to promote fidelity, right? And that way it does enhance the sentence recommendation if there is the use of a weapon.
Because I think some of those cases probably like a parent killing, a child or whatever, probably wasn't. But I think the vast majority of our third degree murders are gun charges. So that may answer or that may change some, at least my philosophy on it when I look at it.
Yeah.
That, those cases certainly were there.
Yeah.
But the bulk of them, I don't know about other jurisdictions. I don't have true zeros most of the time
Right.
on third degree murder.
Yeah. So, and again, we had 57 out of a couple hundred cases or something like that. I forget what the total number of murder 3s were in that sample, of which we got 57, but it seems to me it was quarter case, something like that.
Mark, just from sort of a public policy
Sure.
standpoint, we talked a year ago, whenever we started doing this, about looking at what is being done
Right.
and using that as our starting point.
Yep.
And here, what is being done is high. It
is high.
It's the 20 years, and it's almost as serious a crime as you can have, other murder 1, murder 2, maybe the rape of the child.
Right.
And now we're making a decision to set the guidelines lower, significantly lower than what's being done. I just have an issue with that.
Yeah.
From a public policy standpoint, I
Well,
don't think it's good.
Yeah, I think the assignment, if we're assuming the median's 144, then that would justify a sentence at 29 or well, I guess 29 would be the right assignment. And then if we did a 29 for that, we'd do a 30 for victim less than 13 because of the enhancement requirement. So that would be, you're right, at the top of that. But we do have a lot of cases that are lower than that. And so, like, again, as I said, whatever the commission decides is fine with me. I think if you think you need greater latitude because there's so many circumstances, I think we could look at trying to come up with language that uses the level, because then it would include the recommendations for 29 and 30 in that. But it would also allow for lesser ones, but we're still creating a base that's higher than it is right now, because right now it's 72 and the base for this would start at 90.
But very few are at that 72 level, at least from the data you guys looked at, right?
Right. Zero
most
prior
are at
records
the-
where you-
We're
Well,
much
there
more
were-
20 years than 6 years.
So a couple things also, if you're saying, let's just use F
Right,
and we'll say murder 3, you have the discretion of using all these ranges.
right,
Where once again, you only put reasons on the record if you depart from the standard range.
Mhm.
So we're still going to have this massive range with no data as to where or why they're going. And I understand that in every other place we're narrowing and we get hung up on this, but I think maybe part of it is because we don't have the data on it.
that's correct.
And so could we create, I know you'll love this, but could we do like a G, third degree murder, and just have it across as that? And then maybe with the indication that there, we put in the language that we're requiring reasons on the record, however we want to state
Right.
that, so that we know where it's coming. And then we'll put in there, we'll collect data for 3 years, revisit and restructure.
Right.
But
Well,
I just don't know.
We
how
don't
we're
have a
not-
G
it's-
yet, so you
That's
got
what I'm
that
saying.
going for you.
I say there is no G because they were waiting for murder 3.
Well,
And there you go.
well, H fit homicide. I don't know. There's something going on there. So,
G, got to get more information.
Gee, God,
So-
yeah. Well, look, it's just past 5 and we promised to finish at 5. We do have a dinner meeting where it is published, so we can have further discussion of this or anything else during during dinner, and then we can resume this tomorrow after we talk about SGS Web. But I think, it would be helpful if we're going to move forward with approval for public hearings, having something that you'd like to either test or try to move on with Murder 3, I think would be great. And if it's specific assignments for, using these OGSs and coming up with specific assignments, fine. If you prefer instead to use level F or create a level G with special rules that apply to Murder 3 that we deal with separately, let's talk about what that is. Because even if we use levels, we'll have to decide, how do you do aggravated or mitigated when you have a level rather than an OGS assignment and other stuff like that. So, we'll just need a little more detail from you to put it out for purpose of getting public comment. But with that, we've gone through a lot. I appreciate all your time. It's incredibly detailed information, and look forward to joining you for dinner to even talk about this more. And then tomorrow morning, we'll convene at 9 o'clock right here. First half hour will be the discussion of SGS Web. Christy and our vendors will give you an update on that, and then we'll roll into a discussion of this and the other two sets of guidelines, resentencing and recommitment ranges. Unless there's anything else, Judge, back to you.
All right, so nobody has any other comments. So we'll end the policy meeting, which is adjourned, and then we'll have our dinner meeting, which is published, correct?
Yes, it is.
And then we'll reconvene at 9 a.m. tomorrow morning for our policy.
Sounds great.
Thank you.